Hello, everybody. Welcome. Just need another minute here to get set up. I have a little bit of a different setup today, so please make sure and let me know if anything is not in frame. If you can't see it, just let me know. Today I'm going to be going through Trump versus Cable News Network. This was a defamation case filed last year, and we just had an order come out on Friday on this case. So I will be walking us through the petition, the response, and then the actual order that's come down from the court. So all of these documents are, of course, available online. You can look them up and read it for yourself, or just kind of follow along with me as we go through, trying to make sure everything is in frame okay. So, but this is, yes, that is CNN, the Cable News Network. Yes, I don't think I ever made that connection myself. So I will be going through the order that was set out by the court on Friday, along with the original petition and response to petition by defense counsel. In this case, it's actually a very interesting case on defamation, and there were some huge questions. Our landmark case that governs any of our defamation cases is New York Times versus Sullivan, and they actually asked the court to overturn that case. So it's very interesting, the arguments that are set out in this case. So I thought it would be a great time to kind of explore what defamation is and how we go about it. This case was dismissed on Friday, and they were asking for $475 million in punitive damages. So it's a pretty major case and very interesting, with a lot of great learning points on it. So wanted to share that with everyone today. Hopefully I'm in frame okay for everyone. Again, I'm trying this new setup here, so I want to make sure that everything is properly in frame. There we go. I think that might be a little bit better. Okay, so I will just wait just another minute or two here. I've got one more thing I need to grab, and then I will start going through the documents that were filed, the petition, as well as defense answer and the response to defense answer, and then finally the order that came down from the court on Friday, and this was just a couple days ago. So this was kind of a last minute special request to kind of go through this. I have posted on defamation in the past, just as a general legal concept. And so I think this is a really great way to kind of walk through the issues set out in defamation cases. So I will be back. Well, hello, welcome. I'll be back in just a few moments, and I will get started. Okay, so here we are. This is an interesting defamation case. It was filed last year by Donald Trump against the Cable News Network. And this is in response to some different reporting that had been done. So I want to take us through the original complaint along with the responses. And then finally, the order that came out on Friday, kind of explain a little bit. It's really a very interesting question here. So I thought it would be worth going through. And anytime people tag me on different legal cases, I'm happy to take you through the language on that, so long as it is legitimate. I have a lot of tags on videos that are false, so if it's an actual legitimate case, I'm happy to take a look at that. So here we go. Let's get started. And I have gone through, we have some very sensitive topics in this petition and a few very sensitive words that I don't really choose to put out into the algorithm. So I have kind of crossed out some words. I think everyone will know what I'm talking about, but just sensitive in nature. I have put a cap on 18 and older for this live, so just to make sure that everything is covered, but there will be a few terms in here that are just not words I choose to put out into the world. So just to let you know, this is the court filing number here, and we're in the Southern District of Florida in the district courts, and this is a defamation case. Now, the original complaint was filed October of last year by Mr. Trump. So let's just start there with the complaint and the jury demand. So I will just kind of walk us through the different elements here and what his claim was as he was suing the cable news network, or CNN, for statements that were made, negative statements that he felt qualified as defamation. So let's dive in. Now, in any kind of a civil complaint, each separate paragraph will be numbered. We don't have a lot of law necessarily set out in this particular complaint. I think that's really up to the drafters if you want to use case law and law, and they just didn't choose to do that much in this complaint, but that's just whoever the attorney is that's drafting it can be their style. So let's go through his points here because it is very, very interesting. The plaintiff, President Donald J. Trump, has been a longtime critic of the defendant, Cable News Network, or CNN, not because CNN does a bad job of reporting the news, but because CNN seeks to create the news, fake news, as the plaintiff has characterized in public statements. Beyond simply highlighting any negative information about the plaintiff and ignoring all positive information about him, CNN has sought to use its massive influence purportedly as a trusted news source to defame the plaintiff in the minds of its viewers and readers for the purpose of defeating him politically, culminating in CNN claiming credit for getting Trump out in the 2020 presidential election. So, in a federal complaint. Okay, that's good to know. I certainly have not filed a civil federal complaint, so that is good information to know. But there is some case law cited within this complaint. But now this very first sentence here is a doozy here. They're talking again about we're going into this question of defamation, and so they're setting out maybe a motive the defendant may have. Now, CNN's campaign of dissuasion in the form of libel and slander against the plaintiff, libel is written, slander is spoken, has only escalated in recent months as CNN fears the plaintiff will run for president in 2024. As a part of its concerted effort to tilt the political balance to the left, CNN has tried to taint the plaintiff with a series of ever more scandalous, false, and defamatory labels. As this word, insurrectionist, and ultimately this word, which I have tried to not put out into the algorithm here. So these are what he's claiming he's been called. Oh, hello, Limo, welcome. I hope you have a great day today. These, let's flip to the next page here. Labels are neither hyperbolic nor opinion. These are repeatedly reported as true fact with purported factual support by allegedly reputable newscasters acting not merely with reckless disregard for the truth of their statements, which we'll get into. There's a legal standard regarding that, sufficient to meet the definition of the legal standard for actual malice, but acting with real animosity for the plaintiff and seeking to cause him true harm, the way actual malice commonly is understood. This is Allie, this is a civil complaint that was filed by Mr. Trump against CNN for defamation. The court held on Friday that there were no grounds to go forward, and so they went forward and dismissed the case. So I'm going through the complaint, the answer, and then the language of the court opinion. CNN has been given the dreaded pants on fire designation by PolitiFact for its stories comparing Trump to, I'm just going to use the term bad man. Still, it persists, requiring the time and expense of filing the instant lawsuit. Now, number 2, even though the actual malice standard is met here, in circumstances like these, the judicially created policy of the actual malice standard should not apply because ideological homogeneity in the media or in the channels of information distribution risks repressing certain ideas from the public consciousness just as surely as if access were restricted by the government. This is pretty bold because they're asking for a new standard to be used when it comes to defamation. And so they're specifically saying the traditional standard that we have for defamation should not be applicable here. Suits like these do not throttle the First Amendment. They vindicate the First Amendment's marketplace of ideas. Number 3, as the late Judge Silberman noted, it should be borne in the mind that the first step taken by any potential authoritarian or dictatorial regime is to gain control of communications, particularly the delivery of news. It is fair to conclude, therefore, that one-party control of the press and media is a threat to a viable democracy. It may even give rise to countervailing extremism. The First Amendment guarantees a free press to foster a vibrant trade in ideas, but a biased press can distort the marketplace. And when the media has proven its willingness, if not eagerness, to so distort, it is a profound mistake to stand by unjustified legal rules that serve only to enhance the press's power. Now, I believe that what this judge here is saying is that the legal rules that are in place are perhaps serving this enhancement issue. And so he's questioning the legal rules in place. So this is, again, is a quote from a judge in a case. Yes, exactly. None, you are correct. That is what it is. It is actual malice must be shown. And, honestly, it's a relatively high burden to prove. So next we go to jurisdiction, parties, and venue in our complaint. So number 4, jurisdiction for this cause of action lies within the court, and they're citing the jurisdiction code of the United States Code. This is an action for defamation, and the parties are diverse in citizenship, which again is that legal language for what jurisdiction is appropriate here. Number 5, the plaintiff, President Donald J. Trump, is a citizen and resident of the state of Florida. 6, the defendant, CNN, is a corporation based and operating in the state of Georgia and is therefore diverse in citizenship to plaintiff through the United States Code. Meaning diversity jurisdiction means we've got 2 separate states at play here. So that's what is allowing for. Why is it saying president? Well, this was written by the plaintiff. So this is written by Mr. Trump's attorneys, so they can kind of put in whatever they choose to put. But when we get into the opinion, the judge's order, as well as the defendant's brief, or explanation, we'll probably see a little bit different language used, but that title is appropriate here for this particular document. So I don't think that, I see where you're coming from, but legally I believe it is still an appropriate title for the purposes of this petition. The amount of damages sought in this cause of action exceeds $75,000, thus is meeting the requirement of 28 USC. Of course, we have a minimum requirement here in order to get into a civil jurisdiction at this level. The court may exercise personal jurisdiction over the defendant, CNN, pursuant to this Florida statute, because CNN committed the tortious act of defamation within the state of Florida by broadcasting its defamatory statements to individuals within the state. Further, because CNN conducts business in Florida and has registered in Florida as a foreign corporation, it has sufficient minimum contacts, which is another standard we use for determining jurisdiction, with the state so as to satisfy the due process requirements of the Constitution. So let's go to the next part. I won't be going in through the footnotes just because there's plenty of information in the actual body of the document itself. So if we need any further information, we can hop down to the footnotes. So number 9, and again, please let me know if I'm not in frame well enough for everyone. What does that mean? We're just going again into if there's jurisdiction for this particular court. So they have to show that in any complaint that this court has the authority to hear the case. Number 9, venue is proper in the Southern District of Florida for the following reasons. A, the defamatory statements that form the basis of this lawsuit were published to and in South Florida, in addition to all over the world. As a result, CNN's defamatory statements were accessed and viewed by individuals in South Florida. South Florida has a population of approximately 10 million people, making the alleged defamatory statement in this venue significant. So again, we're just trying to put forward what venue is appropriate, and so you would put that in any complaint. B, because the defamatory statements were published in South Florida, a substantial part of the events giving rise to the instant claim occurred in this judicial district. C, the plaintiff is a resident of South Florida and is domiciled in South Florida. Those are, of course, two different standards, resident versus domiciled. D, the defendant does business in South Florida and has registered in Florida as a foreign corporation, voluntarily choosing to have its registered agent in Broward County, which is where this court is located. So now we've set out venue. So that is under number 9. Next, we've got satisfaction of condition precedent, and that will be our next piece. Oh yes, anyone, if you are just not interested, please feel free to move along. I will not be offended whatsoever. Number 10, the plaintiff provided notice to the defendant as required by Florida law and satisfied all conditions precedent to the filing of this lawsuit. A true and correct copy of the notice letter is attached here too. I do have that notice letter. I'm not going to add it. I don't think it's particularly relevant. Now, CNN has not complied with the plaintiff's demand for retractions of the defamatory statements by way of publishing any such retractions. Now, this is an interesting point here because typically we don't introduce any kind of mitigating actions that the other side has done. So I think bringing up the fact that they've asked for retractions and retractions haven't been done, that's not something that would be able to be put in as evidence in a case. So it's interesting that they have said it here in the complaint. Instead, and as confirmed by email, CNN refused to comply, ratifying its position. And that takes us over into the factual allegations. Now, again, there are some very sensitive words being used in this complaint, and so I will be careful about the words that I'm using, but of course you can read as we go along through here. Yes, it is interesting that he was asking for retractions. And again, I'm not sure why or how, but I think it's always good to ask the other side if they can kind of make amends if there's an issue. Factual allegations. So now we're getting really into the meat of what's going on here. A news network that purports to be trusted and honored. CNN holds itself as the most honored brand in news and the most trusted name in news. It touts reaching more individuals on television and online than any other news organization in the United States. And this is just a caption of their website kind of supporting this statement. So CNN has had the opportunity to review your letter of July 21st, 2022, and evaluate your demand to take it down and retract the 34 articles and television segments you identify as defamatory, and to cease referring to representations made by former President Trump regarding the outcome of the 2020 presidential election as lies. We decline your request. Of course, this is an email from CNN. While we will address the merits of any lawsuit, should one be filed, we note that you have not identified a single false or defamatory statement in your letter. It is well established that the outcome of the 2020 presidential election was unaffected by fraud, as verified by the dismissal of no fewer than 50 lawsuits by judges across the United States asserting otherwise, the sanctioning of multiple attorneys for making unsubstantiated election fraud claims, and investigations conducted by the Department of Justice, Congress, and various state and local bodies. So this is, again, from an email that was sent. As to your preservation demand, we will preserve the relevant materials to the extent required by law. We send this response without waiver of CNN's rights and remedies, all of which are expressly reserved. So they're just saying, hey, we'll go ahead and keep all that info, but until we actually see a lawsuit, that information will be kept as we normally would keep it. That takes us to the next part. Here, so subsection B, a news network that uses its platform to propagate its politics. Again, I'm trying to make sure I'm in frame here. So, purporting to be a trusted news source, again, this petition is being filed by Donald Trump. So this is his view. The next response will be CNN's side. So I will be giving both sides of the story here, along with the order from the court. CNN's anchors have denounced a competing network as providing a buffet of cultural war cuisine and predictably hypercritical, meaning CNN has undertaken a smear campaign to malign the plaintiff with a barrage of negative associations and innuendos, broadcasting commentary that he is like a cult leader, a lackey, a dog whistler to this group, and this. It is the stuff of tabloids cloaked as honored news. And then we have a claim here in a screenshot. Number 13, CNN's reporting on the plaintiff in recent years has consistently fed a narrative to denounce the plaintiff's legitimacy and competency. The reporting is results-oriented as betrayed in an undercover video. A CNN employee was filmed discussing the defendant's coverage of the 2020 presidential election. And we're citing the Washington Examiner news. So that's where that's coming from. I think it's important to know where our sources are. The employee boasted that CNN helped to defeat the plaintiff in the 2020 election and called the defendant his employer propaganda. Look at what we did. We got Trump out. I am 100% going to say it, and I 100% believe it, that if it wasn't for CNN, I don't know that Trump would have got voted out. Again, they're citing a Washington Examiner.com news article. All right, so that's where this language is coming from. The statements by this CNN employee celebrating its media bias are consistent with published statements by CNN commentators. All right, that's interesting. And of course, they're putting forward what they believe is supporting their views regarding the defamatory statements. Next, we've got C, from reporting news to propagating political beliefs to intentional, willful, and malicious libel and slander. Again, for anyone joining us, this is the petition that was filed by Mr. Trump against CNN. Number 15, most notably, and the subject of this complaint, so this is specific to what the defamation charges are, is CNN's persistent association of the plaintiff to a bad man and a bad organization. When labels like this one, lackey, and insurrectionist did not have that desired effect to undermine the plaintiff's candidacy when running for president, or the plaintiff's accomplishments of president, CNN upped the stakes to conjure associations between the plaintiff and arguably the most heinous figure in modern history. That's, I think, a bold statement again, showing the damage that he found by being compared to this bad person here. CNN's persistent use of ever-increasing defamatory characterizations of the plaintiff up to and including him as this bad man and organization demonstrates that it published its defamatory statements about the plaintiff with actual malice, which again is that legal standard that we need for defamation. Number 16, on January 9th of 2022, CNN aired its special report, The Fight to Save Democracy, by CNN anchor Fareed. In the promotional video for the program, Zachariah states, democracy everywhere is under attack. But remember, America has been here before. America has vanquished demagogues before. So how do we do it now? Okay. I absolutely do not mind any discussion back and forth, but blatantly false statements are not permissible. Yes, so just please keep that in mind during your commenting. I make that a very important point here on my particular TikTok. I'm absolutely happy to hear both sides, but if it's a completely false statement, it's not permitted here. So now we move on, and we're going into, again, this special report, which is quite a bit of what the issue was here. Oh, thank you. Thank you. All right, so, and this is, of course, incredibly offensive, so I've just kind of covered it up. So here we go. The report goes on to discuss the plaintiff's challenge to the election integrity in the 2020 presidential election, and that democracy is under attack, not because of potential fraud in the election process, but because the plaintiff questioned the election results. A focal point of the report is discussion of the ascendancy of this bad person and comparisons to the plaintiff, interspersing discussion of the bad man and the bad organization with footage of the plaintiff. The reporter states in the report, let's be very clear, Donald Trump is not this bad man, but the disclaimer is lost in an otherwise direct and graphic analogy. So, number 17, the effect on viewers is apparent from responses to the program on Twitter. So we're citing Twitter as a way of showing that this was published and a negative connotation that was going on. Excellent and chilling, and let me just take a moment here to say I usually don't quote Twitter, but this is a judicial complaint, so this is the exact language in the complaint. So the parallels with the rise of the bad man are obvious and undeniable right now to the lies and conspiracy theories. This journalist lays out ways in which this threat is real and parallels historical threats, quoting, the similarity between the bad man in the 1930s, Germany, and Trump in 2016 are notorious, and the way you made the segment by, on, and off alternate images of both, even if not apparent before, you made it now. So, again, this is a petition filed by Mr. Trump with regards to defamation. Okay, so just clarifying where I'm at here. So let's flip the page. And again, I'm not going to go through and specifically read this information. These are tweets on Twitter, so this is part of the complaint. You can kind of look up that information. Oh, sure. Right now I'm going through the civil case, Trump versus CNN, and the court dismissed the case on Friday. So right now I'm going through Mr. Trump's complaint against CNN for defamation. On August 25th of 2019, CNN broadcast its Reliable Sources program, hosted by then anchor Brian Stelter, an interview with psychiatrist Alan Francis. In the broadcast, Francis claimed that Trump is as destructive a person in this century as this bad man number 2, bad man number 3, were in the last century. Francis's statements were analyzed by PolitiFact, a website that holds itself out as a fact-checking website and rates the accuracy of claims by elected officials and others on its truthometer. Forgive me, I have no idea what this website is, so hopefully I've said that correctly. This website then determined that Francis's statements regarding the plaintiffs merited the pants on fire rating of untruth. Now, of course, I've heard of the pants on fire idiom. We use that quite a bit. But flipping then, and then of course down here, we've got the exact citations to the different places where they're pulling this information from. So that's number 18. Going back over here, again, this is a screenshot of that actual comment, and it's a screenshot from this website up here in this petition by Mr. Trump. CNN recently canceled Stelter's Reliable Sources program, which was made public on August 18th of 2022. Reporting on the cancellation identifies Stelter's historic bias against the plaintiff, Republicans, and non-liberal news outfits. And we're citing here, again, we've got number 19 as our footnote. We're citing foxnews.com. So it looks like this was a story that was posted August 19th, and also variety.com posted August 19th. So that's the sources here for identifying his bias. I believe it's a him. I don't know who this is, but number 19, additional reporting by CNN that associates the plaintiff with the bad man include a March 20th, 2019 broadcast with the headline, Top House Democrats Compared Trump's Rise to This Bad Man. The reporting is nothing more than self-serving pronouncements by political opponents of the plaintiff and their news proxy and political participant, CNN. So again, this is the, again, I just give a cautionary tale. I am fine with any political discussion whatsoever, but blatantly false statements are not permitted here. Just as a heads up. Here we go. Now we've got, again, CNN Politics, and we have a screenshot to support this statement up here. On December 31st of 2019, CNN Anderson Cooper, and I have heard of that name, interviewed singer Linda Ronstadt, who I've also heard of on her views of the plaintiff and her comparison between America under the leadership of President Donald Trump and Germany under the leadership of this bad man. No matter how lovely a voice she may have, Ronstadt is a singer, not a historian. The interview is merely a pretext to repeat CNN's message under the guise of real reporting. More problematic is the use of celebrities to propagate CNN's message. That's a good point. The use of celebrities. And then here I believe is a clip added to support that. On July 17th, Jim Acosta, host of CNN's Newsroom, again, I'm not sure who that is, stated, when we have entered the realm of coups and this bad man, we have to pause. This statement is the title of CNN's YouTube post of the broadcast segment. The segment of the broadcast begins with Acosta stating, this week, President Biden took on the big lie and the insurrection. And then we've got another screenshot here. So, we don't have any sworn witnesses here. This is a complaint, so that is not required in a complaint. The facts set out in a complaint are the facts put on by that party, and however We want, however the party wants to put it is up to them. I think I've heard of Acosta, but I've never really taken a look. I don't watch a lot of that stuff, I guess. I have different sources I use for all of my intake of information. So I really don't dabble too much in that, although I believe I have heard that name before, but is not sure who it is. Should someone wanting to win use witnesses in a complaint? Well, I think they are putting forth the evidence that they have supporting their allegations. Well, I don't know who Jim Acosta is. No, I do not. I'm very careful and limited in what I consume out in the world to try to remain as neutral as possible. So no, I do not. A search across a news database for instances in which Trump appears within 10 words of this bad man or this bad organization in CNN broadcasts since November of 2016 produces at least 645 results. And that's according to a Westlaw news database. As evidenced in tweets found by this journalist, January 19th of 2022 special report, viewers took their cues from CNN. The similarity between this bad man in the 1930s, Germany, and Trump in 2016 are notorious. The effectiveness of CNN's propaganda on its viewers is demonstrated in opinion polls. For instance, an NBC News Wall Street Journal poll from 2019 found that 99% of CNN viewers believe that the plaintiff lied about the Russian investigation. And let's see where this source is. 25, so we've got newsbusters.org, and it's a blog here from March 4th of 2019. CNN's intent to malign the plaintiff has had the desired effect on its viewers. So number 2, defamation, that is the subject of this complaint. CNN's use of the big lie, a concept told to this bad man to describe the plaintiff. Number 22. Would a blog be credible? Well, I mean, that's really up to the jury to decide. Again, when you are drafting your complaint, you can kind of put in whatever it is you need that you feel supports your position on the complaint. So you can kind of add whatever you want so long as it is a legitimate source under the jurisdiction that you're filing it in. Typically, yes, a blog is an opinion, and when it comes to defamation, opinion versus fact is a huge issue. Yes, it does feel that way. I would say, and I'm not sure, I don't care whose blog it is, you want to kind of double check. But again, you can cite whatever sources that you feel are relevant when it comes to a complaint. One of the most persuasive associations between the plaintiff and this bad man that CNN has employed is the use of the term big lie in relation to the plaintiff's stated concerns about the integrity of the election process for the 2020 presidential election. In its campaign of dissuasion, CNN has branded the plaintiff. I was not expecting to see dissuasion following the word campaign there, so I had to pause. In its campaign of dissuasion, CNN has branded the plaintiff as one who subscribes to the notion of the big lie. The big lie is a direct reference to a tactic employed by a bad man and appearing in the bad man's book. As commonly understood, if you tell a lie big enough and keep repeating it, people will eventually come to believe it. And here we are citing the jewishvirtuallibrary.org. So that is that citation. The big lie was used by this bad man to incite hatred of the Jews and to convince people to ostracize these Jewish people. I don't want to cross that out. I don't feel that's an inflammatory word, but I'm not sure about the algorithm here, so I'm just trying to be sensitive here. It was an entire propaganda campaign to justify Jewish Jewish persecution and genocide. That phrase is not taken lightly, and it is not bandied about blithely. CNN anchors and commentators understand this. They have not used it against other political leaders and previously criticized political analogies to bad place and to bad man. Interesting. 24. In a CNN broadcast of September 4th of 2012, CNN anchor Ashley Banfield discussed a statement by then chair of the Democratic Party in California, John Burton. Banfield noted that Burton actually compared Russians to this group of bad people. She read Burton's statement during the broadcast. They lie and they don't care if people think they lie. As long as you lie, the big lie, you keep repeating it, you know. Banfield continued with background on this person, a Nazi propagandist under this other bad person. Paul Steinhauser, a CNN political director appearing on Banfield's show, responded, "No, not cool. The bad group comparisons never work in politics. This is another example of why you don't or should not do that." Banfield stated, "I'm getting sick of both parties calling people this bad group of people. It's stupid and sick." Okay. The sentiments relayed by Banfield and Steinhauser bear little resemblance to current attitudes at the network. CNN has adopted the big lie. Ooh, that's a bold statement, as its turn of phrase to describe the plaintiff and plaintiff's concern over election integrity. The repeated use of the big lie in relation to the plaintiff is not innocently rendered, but rather a deliberate effort by CNN to propagate to its audience an association between the plaintiff and one of the most repugnant figures in modern history. As CNN's editor-at-large notes, the insidiousness of Trump's big lie is like an earworm wheedling its way into the consciousness of the public. These associations have an impact on CNN's audience, as can be seen in the viewer responses above. So, just as an interesting side note, we've got a citation here of a CNN.com article that was written. Next, we've got CNN's willful and continued use of the big lie characterization. On June 15th of 2022, CNN's new chairman and chief executive officer, Chris Leich, reportedly held a conference call with top CNN producers in which he expressed displeasure with the use of big lie. Since then, and let's look and see where that source is, number 29 down here. That's according to a foxnews.com article. And this says last visited August 20th. So I'm not sure if that's the last visited time or if that was the actual date of this. Not sure, but that's could still be found if you needed to look that up, which is all that's really needed for a citation. Since then, CNN's on-air personalities, including John King, Jake Tapper, John Avalon, Brianna Keeler, and Don Lemon, among others, have continued to use the phrase in describing the plaintiff and the plaintiff's questions of election integrity, despite an apparent admonition from the chief executive officer. Okay, so that's interesting. Number 27, reportedly the term big lie has been used in reference to the plaintiff more than 7,700 times on CNN since January of 2021. And that, again, is citing, this id is going to cite this endnote, which takes us back here to this Fox News article. Of the estimated 7,700 times that CNN has used the term the big lie in reference to the plaintiff, 5 examples that were provided in the plaintiff's notice letter that CNN refused to retract are the following. So A, on January 25th of 2021, CNN published an article written by this person, a frequent contributor to CNN Opinion, entitled "Trump's Big Lie Wouldn't Have Worked Without His Thousands of Little Lies." This person wrote, "This is Trump's big lie, a brazen falsehood with momentous consequences." And then again, this is just citing that previous article, but let's just double check. I want to make sure that this direct quote is that same article, and it is. Let's just look at this citation a little closer here. We have foxnews.com going through this one, and we're still at 29. We haven't hit 30 yet. Let me just double check. I want to make sure my site is correct. We have hit 30. Okay. I want to make sure, again, that we get it correct. So 30 is citing a CNN.com opinions, big lie, and then that author index. Again, last visited August 20th here. So let's pop back over. I wanted to make sure I had my citations correctly. So this is a citation to a CNN article. So this is, and the reason I go through this is because, again, it's the content of the words that have to do with the defamation suit. So let's go through this language that they're alleging is defamatory. So this author likened the plaintiff to an authoritarian dictator, writing, Trump, a leader of authoritarian intentions and tendencies, had disadvantages with respect to the foreign autocrats he so admires. He had no state media like China's guy. He could not rule by decree like Hungary's guy. He had to govern and run for re-election in an open society with a relatively robust free press. Moreover, although he succeeded in making journalists into hate objects for many of his followers, he could not revoke or destroy the First Amendment. Okay, so this is, again, a piece that they're claiming is a defamatory statement. So Trump took a different tact, unleashing a barrage of disinformation common in authoritarian states, but without precedent in the history of the American presidency. He told more than 30,000 documented lies in public. 30,573 was the Washington Post's final tally. So this author is citing the Washington Post for her information on Twitter, at rallies and interviews. If taken as an average, that would be 21 lies per day over his 4-year term. Again, please keep in mind that these citations are being pulled out of different other citations. So B, on July 5th of 2021, CNN published an article written by this person, an editor at large, entitled Donald Trump Just Accidentally Told the Truth About His Disinformation Strategy. And let's look and make sure we have the proper citation here. This is another CNN citation. In this article, CNN's editor at large likens the plaintiff to this bad organization's propagandist, bad person. One can only hope that Trump was unaware his quote was a near replication of this infamous line from this bad man. If you tell a lie big enough and keep repeating it, people will eventually come to believe it. And that's another quote directly from CNN. True. I am not going into the exact, I'm not double checking on the citations at the moment. I'm kind of just getting through the complaint, but highly recommend going in and double checking that. On September 15th, 2021, CNN published an article written by this person. Donald Trump's mental health becomes an issue again. And this is a citation out of another CNN.com article. In this article, CNN editor at large wrote that President Trump's continued to push the big lie that the election was somehow stolen, despite there being zero actual evidence to back up that belief. And they're quoting that CNN article, emphasis added. On January 26th, and again, each one of these are different pieces of defamation that he is claiming has had such a negative effect on him. Okay, the election. Okay, friendly reminder yet again, I'm all for political debates, but I will, actual factual information is not part of what I'm doing here. So on January 16th of 2022, CNN aired a television show entitled State of the Union that included host Jake Tapper making the following comments. let's look to our source again. So down here, we're going into transcripts off of the CNN website. Okay, so Tapper, over the weekend, while Martin Luther King the third, that doesn't seem correct, was in Arizona rallying to expand voting rights. Oh, okay, I get you now. I get you. I was going back further in time. Donald Trump was, the same day, in the same state, doing the exact opposite, continuing to push his big lie. And then there's a video clip. So again, I think it's this language, the big lie, that they're talking about with regards to that defamation. Trump, last year we had a rigged election and the proof is all over the place. They always talk about the big lie. They're the big lie. End of video clip. Tapper, there is a reason Trump was in Arizona to push the legislature to disenfranchise the state's voters based on all of his deranged election lies. And emphasis added. On February 11th of 2022, CNN published an article written by this person, the editor at large, entitled, "Here's the Terrible Reality. Trump's election lie is on the march," and with a link entitled, "New Poll Suggests Trump's 2020 Election Lie is Working." In the article, this person claims, and then again, let's just look to our source here, 34, which is a CNN.com article. So the author, editor at large, is saying, this is the insidiousness of Trump's big lie. It's like an earworm. You may hate the song, but you just keep finding yourself humming in the shower. Trump has created a constant low-level buzz within the American electorate that something is wrong with the way we conduct elections, that he has no proof, doesn't seem to matter. By sheer reputation, his false claims are wheedling their way into the consciousness of the public. So that's what that article said. And then we flip over to 29. And again, I'm just going through the complaint for his suit for defamation against CNN. CNN's highly defamatory and persistent association of the plaintiff to this bad man and this bad man's big lie is no mistaken misappropriation. It is wanton and malicious reporting intended to feed a narrative and to achieve a desired end, to cause readers and viewers to associate the plaintiff with the lowest of low, to fear him, to not vote for him, and to support campaigns against him. The inflammatory reporting is not intended to help discover the truth or actual facts or to help educate readers and viewers to come to their own informed decisions. It's intended to aggravate, scare, and trigger people. Indeed, the bad person characterization is one that courts across jurisdictions have historically considered defamation per se. Now that's a bold statement there. Let's look where the support is for that. We've got State v. Goon, which is a Tennessee case. So that's Tennessee law. We've got Pennsylvania being cited. So Pennsylvania law, and this was 1961, 1947. We've got Southwest Digest again, second, 1946. So we've got some case law here that we're citing from multiple jurisdictions. Well, I think the statement that he's making, he's trying to say that it's a bold statement. So just by the language used, anytime you use this term per se, it's a huge hit against whatever you're talking about. So that's why I'm using that language. And then he's got these cases here supporting that idea that across different courts, it's considered defamation. So CNN's malicious selective use of the big lie characterization to single out the plaintiff. CNN has singled out the plaintiff as a purveyor of the big lie while choosing not to challenge others who have suggested election infirmities. So just as a side note, and again, I'm not picking any sides here, but my question, I just have a general question, is this idea that if they had applied this big lie to other political people, then it would not have been a defamation? That's my question here, because they're saying they singled him out as this purveyor of this, but chose not to challenge others. And so Had they challenged others, then would it not have been a problem? I'm not sure. I'm not sure exactly what the is. Yes, per se. That's correct. But when you say, like, if you don't have a warrant, it's going to be per se unconstitutional. It means that instantly the court's going to take a look at it and say, why don't we have a warrant? So is what I'm meaning there. So, okay. And so next we've got, I think, an example. Anyone can file a tort. Correct. Anyone most certainly can. When Stacey Abrams lost the Georgia governor's race in November of 2018, she claimed the election was stolen from her, a claim she repeated in 2019 State of the Union response. And here we go. In response to what I believe was a stolen election, I'm not saying they stole it from me. They stole it from the voters of Georgia. I cannot prove empirically that I would have won, but we will never know. And so what I demanded on November 16th was a fair fight, because you see, voter suppression is as old as America. So this is what he's citing as another instant of a political person involving questions of a stolen campaign. And the source here is CNN. And that takes us then to the next page. Now, we are almost to the ends here of this complaint, and then I will go into the response to what CNN said. So, Abrams was interviewed on November 19th of 2018 by then CNN anchor Chris Cuomo about her election loss. Now, that is a person I have heard of. About her election loss and challenges to election integrity. In her interview, she claimed machines were flipping names because of the antiquated nature of our machines. We had people who were purged from the rolls unlawfully. We had new citizens who were denied the right to register. We had thousands who were placed on hold. Let's check that citation here. We've got transcripts from CNN. Cuomo did not challenge these claims, but asked Abrams how her initiative, Fair Fight Georgia, would fix the problems identified. Cuomo noted that anything that makes the process more fair is good. Number 33. Yes, CNN has not referred to Stacey Abrams as lying or perpetuating a big lie, even in the absence of data supporting her claims of a rigged election. That's interesting. Instead, CNN recognized challenges to election integrity as valid and credible when addressed through a different political lens. That's a very, very interesting point. 34. Going back further to 2016, CNN also failed to challenge Democrats who gave numerous televised statements claiming the 2016 presidential election was illegitimate. This included suggestions that this country's interference caused the plaintiff to win, and regular references to the plaintiff being an illegitimate president. CNN repeatedly allowed for assertions that the plaintiff was illegitimately elected, largely to go unchallenged, including statements made by Clinton, Harris, Biden, Carter, Nadler, Lewis, Feinstein, Fudge, and Wasserman Schultz. None of these individuals who challenged the legitimacy of the 2016 presidential election were accused of propagating a big lie or even lying. Well, again, that's a very interesting, okay. Look, again, friendly reminder, I'm absolutely fine with political differing, but actual incorrect and false statements, I kind of try to keep an eye on those. So let's just kind of keep it a good, clean fight here. But yes, that's interesting because we're talking about in the past, so I'm not sure how the current news story would have covered in the past, but it's interesting, worth noting. Okay, and with regards to one-day voting, none of that is None of that is correct, Katie. We've got all kinds of very complicated voting rules. So I will say that voting procedures are not specified within the Constitution, and what voting procedures we did have been changed through various amendments and so on. Are there people lying in the chat? Okay, please don't lie in the chat, please. Thank you very much. Keeping my moderators busy. I'm just double check. I am an attorney. I'm a licensed attorney. I certainly wouldn't say I'm a big-time lawyer on TikTok. That would be completely incorrect. I am just a regular lawyer who happens to go on TikTok and explain paperwork. So, yes. And no, I'm afraid I do not take any clients through TikTok. I'm just here for educational purposes. So, all right, back we go. Back into the paperwork. Here we go. Well, yes, it is called Election Day. Excellent point. But how it goes about has been changed quite a bit. And in fact, of course, we had the poll tax, which was a voting rule that was completely unconstitutional. And so we had to add an amendment to the Constitution over that. So there are a lot of different voting rules out there. And whether or not they're constitutional is kind of a case-by-case situation. So here we go. CNN's disparate treatment of public figures who support its narrative versus those who do not, such as the plaintiff, is a clear indicator of CNN's malice. Okay, I get it now. They are using these examples to show intent of malice and evidence that the defendant is not reporting the news, but rather propagating its political views. 36. The plaintiff brings this action to vindicate his reputation as a dedicated public servant and to establish CNN's liability for the harm it's caused to his reputation by the false, defamatory, and inflammatory mischaracterizations of him. The plaintiff seeks an award of compensatory damages for the reputational harm caused by CNN, and given the willful and malicious nature of CNN's conduct, that it is intended to interfere with the plaintiff's political career. That the plaintiff also seeks an award of punitive damages. The plaintiff requests compensatory damages in the amount in excess of $75,000, and that means it'll be left up to the jury. The jurisdictional limit as to be determined at trial, and punitive damages in the amount of $475 million. So let's see where we get that number from. That's a big number. That's almost $500 million. So 39, we're coming down here. That number is CNN's estimated profit for 2022 is $950 million. So they're asking for half of that for punitive damages, a significant portion of which was generated by. So they're saying here they want half of the profits that they believe CNN gained from using this information. Yes, half of the profit. It seems like a lot, but again, punitive damages are specifically in order to punish a particular party. So back up we go. We've got this here. So claims of relief. Count 1, defamation per se. The plaintiff repeats and realleges paragraphs 1 through 36 of this complaint, inclusive as if fully stated herein. So we've gone through his defamation per se. Now we go over to CNN has published and broadcast the term the big lie in relation to the plaintiff repeatedly, both in articles on CNN.com as well as in broadcasts on its news channel and streaming services. CNN has acknowledged that the term, the big lie, was a direct reference to this bad man and this bad man's organization, and uses the term in relation to the plaintiff to create false or incendiary association between the plaintiff and this bad man. Examples of times in which CNN has used the term, the big lie, in reference to the plaintiff and about which the plaintiff notified CNN in his notice letter are identified in the paragraph of this complaint. These defamatory statements, which associate the plaintiff's character with that of this bad man, are reasonably understood to be statements of fact as opposed to hyperbole or mere opinion regarding the plaintiff and were reasonably understood by readers and viewers to be statements of fact. Why do I not say certain proper names? I'm not good with people's names. I've always been bad at it, and that is a personal fault of mine that I need to work on. And not hyperbole or mere opinion, readers and viewers understood the plaintiff would be this bad man like in any future political role. 42, the statements are false and defamatory per se. 43, injury to the plaintiff's reputation is readily apparent as evidenced by viewer responses to the statements and viewer polls regarding the plaintiff. Indeed, animus towards the plaintiff and the plaintiff's family and those who are associated with the plaintiff is well recognized by the public. By publication of these defamatory statements, CNN has incited readers and viewers to hate, contempt, distrust, ridicule, and even fear the plaintiff, causing injury to the plaintiff's reputation, and the plaintiff's political career. Being likened to this bad man is historically defamation per se. As such, a comparison tends to subject the target and has subjected the plaintiff to hatred, contempt, distrust, ridicule, and even fear. The comparison has had an adverse impact on the plaintiff's reputation and political career. 46. When a public official or a political candidate is likened to this bad man, it is defamation per se, as the statement imputes a characteristic or condition incomparable with the proper exercise of that public office. And let's look where this quote's coming from here. We have number 40. So we come down here, and where are they citing? Irrespective of what elements must be proven, allegations that impute the plaintiff of character. I don't see a citation. I just see a further explanation to the extent the law in this course. Okay, so this is just a further argument. I'm not sure why we've got a subsection. Maybe they just didn't want to add on information. Okay, so 47, CNN published these defamatory statements with actual malice in that they knew the association of the plaintiff's character with that of this bad man was false, defamatory, inflammatory, or they published the statements with reckless disregard of the truth. Again, this is our other standard for defamation or falsity. CNN did so in order to propagate its political views. And let's see where that's coming from. Down here, number 41. While the allegations in this complaint meet the actual malice standard set forth in New York Times v. Sullivan, that standard does not and should not apply here, where the media is defendant, is not publishing statements to foster debate, critical thinking, or unfettered interchange of ideas, but rather seeks to participate. Okay, so this is the moment in time, the historical moment in time, when they're saying that the defamation standard that we've used in New York Times versus Sullivan in 1964 should not apply to this situation. So they're asking this district court in Florida to overturn the United States Supreme Court's standard for defamation. That's bold. That's a bold move. 48. These defamatory statements were made by each commentator in course and scope of their employment relationship and or agency relationship with CNN, thus making CNN vicariously liable for any and all damages resulting from each commentator's tortious conduct. That would be res spondit superior. In addition to CNN being directly liable for the publication of false statements and for its failure to exercise due care to prevent publication or utterance of such statements. So not only the commentators, but also the boss. And 49, CNN failed and refused to retract or correct the false and defamatory statements. Okay, now we're coming kind of down to the last couple of pages here. CNN has used the term the big lie in relation to the plaintiff to associate the plaintiff with a bad man intentionally, willfully, maliciously, and in conscious disregard of the truth, to do the plaintiff harm and to betray his image and reputation to CNN's audience. As a result of CNN's libelous and slanderous association between the plaintiff and this bad man, CNA readers and viewers of follow-on articles and broadcasts identify the plaintiff as this bad man-like. Okay. I'm also just keeping an eye here on the chat. Y'all are being all right, aren't you? Thank you very much. Thank you kindly. CNN has no applicable privilege or legal authorization to publish these false and defamatory statements, or if they did, they abused that privilege. That would be an affirmative defense if they were to plead that. 53, the defamatory statements have been repeated and republished in other media outlets, which was reasonably foreseeable. Again, another legal standard. Because CNN is a national news organization with a broad national and international audience. At the time these statements were published, CNN knew they would be republished and disseminated to other and larger audiences. 54, CNN is liable for compensatory damages arising out of the defamation of the plaintiff. CNN is also liable for punitive damages because of the wanton and outrageous nature of the defamation. The actions of CNN presented in this complaint demonstrate common law express malice, actual malice, egregious defamation, and insult. Such actions by CNN were undertaken with 1. Maliciousness, spite, ill will, vengeance, and/or deliberate intent to harm the plaintiff, and 2. Reckless disregard for the falsity of their speech and its effect on the plaintiffs. Such actions by CNN did in fact harm the plaintiff. Specifically, the factors justifying punitive damages include, at minimum, the following. So now we will get into how he's been harmed. And so what kind of damages he's looking for is based off of the harm that was done to him. So let's take a look at what they're saying, how he was harmed. By comparing the plaintiff to violent dictators and repeatedly using inflammatory language, such as Trump's big lie, CNN knowingly made false and defamatory statements about the plaintiff, or at the very least, made those statements with reckless disregard for their truth or falsity, thereby acting with actual malice. All right, so that's not really stating a harm that was done specifically. But let's go further here. CNN knew that its false and defamatory statements about the plaintiff would infringe on his rights and damage his reputation, as evidenced by the fact, okay, this is what we need. We need the evidence, as evidenced by the fact that CNN anchors were explicitly instructed by CNN's CEO to stop using the phrases, the big lie. CNN's knowledge of the false and defamatory nature of its statements is further demonstrated by the statements of political director Paul Steinhauser, who emphasized that analogizing politicians to this bad man and the bad man's organization was both stupid and sick. So he's saying he didn't specify any evidence yet. CNN made false and defamatory statements about plaintiff with common law express malice, as evidenced by the comments of a CNN employee who admitted that CNN's coverage and negative characterizations of the plaintiff were intended to convince viewers to vote for him. Okay, here we go. Here's the damage. Here's an actual damage. Let me just double check here. Okay. So here we go. We've got an actual damage here. The malice was targeted nature of these characterizations is also evidenced by CNN's refusal to condemn election integrity concerns voiced by public figures who perpetuated CNN's preferred political agenda. All right, now those comments though were made in 2016 and 2018, and that was before the story was done. So I'm not sure about that one. But we do have some harm here. CNN engaged in willful, wanton, and intentional misconduct in making false and defamatory statements about the plaintiff. The falsity of their statements is underscored by fact-checking from PolitiFact, which has characterized CNN's description of the plaintiff as a leader who is destructive as this very bad man, as untruthful. CNN has refused to retract or correct the false and defamatory statements as evidenced by the email sent by the plaintiff. The articles, news, reports, and social media posts containing the false statements and defamatory statements about the plaintiff remain available to a worldwide audience on CNN's website and social media web pages. 56. Because at the time of the injury, and I guess the injury would be the injury to his political potential I believe, is what they were talking about earlier in the prior page. Because of the time of injury, CNN had a specific intent to harm the plaintiff. And because CNN's conduct did in fact harm the plaintiff, there's no statutory cap on punitive damages, and the plaintiff may recover in excess of $2 million. And I would say $475 million is in excess, and in excess of 4 times his actual damages, the limits that Florida laws otherwise would provide. And then we've got the Florida statute. And if anyone's been watching the law in Florida, there have been quite a bit of caps that have been set out on damages. So, count 2, defamation. And again, just a heads up, we are coming down to the end of this petition. Then we will go into the response from CNN and then ultimately the order. So we're just getting all sides here. 57. The plaintiff repeats and realleges paragraphs 1 through 36 of this complaint, inclusive and, if fully stated herein. 58. CNN has published and broadcast the term "the big lie" in relation to the plaintiff repeatedly, both in articles on CNN.com as well as broadcasts on its news channel and streaming services. 59. CNN has acknowledged that the term "the big lie" is a direct reference to this bad man and his bad organization, and uses the term in relation to the plaintiff to create false or incendiary association between the plaintiff and the bad man. Examples of times in which CNN has used the term "the big lie" in reference to the plaintiff and about which the plaintiff notified CNN in his notice letter are identified in paragraph 28 of this complaint. These defamatory statements, which associate the plaintiff's character with that of the bad man, are reasonably understood to be statements of fact as opposed to hyperbole or mere opinion regarding the plaintiff, and were reasonably understood by readers and viewers to be statements of fact, not hyperbole or mere opinion. Readers and viewers understood that the plaintiff would be a bad man-like in any future political role. 62, these statements are false and defamatory. 63, injury to the plaintiff's reputation is readily apparent as evidenced by viewer responses to the statements of the viewer poll regarding the plaintiff. Indeed, animus towards the plaintiff and the plaintiff's family and those who associated with the plaintiff is well recognized by the public. 64, by publication of these defamatory statements, CNN has incited readers and viewers to hate, contempt, distrust, ridicule, and even fear the plaintiff, causing injury to the plaintiff's reputation, and the plaintiff's political career. 65. CNN published these defamatory statements with actual malice in that they knew the association of the plaintiff's character with that of the bad man was false, defamatory, and inflammatory, or they published the statements with reckless disregard for the truth or falsity. CNN did so in order to propagate its political views. Again, this is the complaint that was written by Mr. Trump. So, 66, these defamatory statements were made by each commentator in the course and scope of their employment, relationship, and/or agency relationship with CNN, thus making CNN vicariously liable for any and all damages resulting from each commentator's tortious conduct. In flipping the page, again, we are almost done here with our original complaint. Addition to CNN being directly liable for the publication of false statements and for its failure to exercise due care to prevent publication or utterance of such statements, that's our legal standard for defamation, CNN failed and refused to retract or correct the false and defamatory statements. 68, CNN has used the term "the big lie" in relation to plaintiff to associate the plaintiff with this bad man, intentionally, willfully, maliciously, and in conscious disregard of the truth, to do the plaintiff harm and to betray his image and reputation to CNN's audience. 69, as a result of CNN's libelous, slanderous associations between the plaintiff and the bad man, CNN readers and viewers that follow on articles and broadcasts identify the plaintiff as like this bad man. 70. CNN has no applicable privilege or legal authorization to publish these false and defamatory statements, or if they did, they abused the privilege. Again, this is really mirroring what was done for the first count. 71. The defamatory statements have been repeated and republished in other media outlets, which was reasonably foreseeable. Because CNN is a national news organization with a broad national and international audience, at the time these statements were published, CNN knew that they would be republished and disseminated to other and larger audiences. 72. Plaintiff alleges damages as a direct and proximate result of CNN's defamatory actions, including that the plaintiff has suffered and continues to suffer damage, including but not limited to damage to his reputation, embarrassment, pain, humiliation, and mental anguish. Now we've got, again, a clear moment where we've got specific damages being specified. And this is the first time, other than damage to people voting for him, where they actually are specifying the harm that has actually come to him. So this is an important piece when you're pleading this. So 73, CNN is liable for compensatory damages arising from the defamation of the plaintiff. CNN is also liable for punitive damages because of the wanton and outrageous nature of the defamation. The actions of CNN presented in this complaint demonstrate common law express malice, actual malice, egregious defamation, and insult. Such actions by CNN were undertaken with maliciousness, spite, ill will, vengeance, and/or deliberate intent to harm the plaintiff, and with reckless disregard of the falsity of their speech and its effects on the plaintiff. Such actions by CNN, in fact, did harm the plaintiff. Specifically, those factors justifying punitive damages are, at a minimum, the following. Now, let me glance through because I believe these are exactly the same thing. Yes, this is exactly the same language that was pled earlier. So, let's see. We've got actual malice here. So by comparing the plaintiff to violent dictators and repeatedly using inflammatory language, such as Trump's big lie, CNN knowingly made false and defamatory statements about the plaintiff, or at the very least, made those statements with reckless disregard for their truth or falsity, thereby acting with actual malice. B. CNN knew that its false and defamatory statements about the plaintiff would infringe on his rights and damage his reputation, as evidenced by the fact that CNN anchors were explicitly instructed to stop using the phrase, the big lie. Let's see, I will take this moment again to remind everyone to please be respectful in the chat if you could. I'd appreciate that. Political debate is always fine, but let's just kind of keep it respectful, if possible, please, so my moderators don't have to get burned out too quickly. And moving on, CNN knew that its false defamatory statements about the plaintiff would infringe on his rights, damage his reputation, as evidenced by the fact that CNN anchors were told to stop saying it. And again, we go down. CNN's knowledge of the false and defamatory nature of its statements is further demonstrated through the statements of political director Paul Steinhauser, who emphasized the analogizing politicians to this bad man and his bad organization was both stupid and sick. C. It's not a joke. It was dismissed, but this was actually filed, and we will. I will go into the defense's response next. Yes, dismissed with prejudice, which is pretty significant. CNN made false defamatory statements about the plaintiff with common law express malice, as evidenced by the comments of a CNN employee who admitted that CNN's coverage and negative characterizations of the plaintiff were intended to convince viewers to vote him out of political office. I want to pause here because this, if everyone will remember when we started talking about this complaint, is a quote from an article done by Fox.com of a CNN employee. And we don't know who that employee is or the context at all. So this is just one unidentified employee being interviewed by Fox. The malicious and targeted nature of these characterizations is also evidenced by CNN's refusal to condemn election integrity concerns voiced by public figures who perpetuated CNN's preferred political agenda. And that takes us then to the almost last page of the complaint here. CNN engaged in willful, wanton, and intentional misconduct in making false and defamatory statements about the plaintiff. The falsity of these statements is underscored by fact-checking from PoliticaFact, which has characterized CNN's description of the plaintiff as a leader who is as destructive as this historical bad man, as untruthful. CNN has refused to retract or correct the false and defamatory statements as evidenced by an email sent to the plaintiff. These articles, news reports, social media posts containing false and defamatory statements about the plaintiff remain available to a worldwide audience on CNN's website and social media web pages. So this takes us to our very last point here before we get into the defense's response. Because at the time of injury, CNN had a specific intent to harm the plaintiff, and because CNN's conduct did in fact harm the plaintiff, there is no statutory cap on punitive damages, and the plaintiff may recover in excess of $2 million and in excess of 4 times his actual damage. The limits in the Florida law otherwise would provide, and then here's the statute. So, prayer for relief. Here's the demands from the complaint. We've got compensatory damages in the amount of excess of $75,000, punitive damages in the amount of $475 million, all taxable litigation costs, pre-judgment interest and post-judgment interest, and a trial by jury. So, and we have it signed here by the attorneys in the case. So that completes the complaint that was filed by Mr. Trump against CNN for defamation. Okay, so this was filed October of last year. Now that we've gone through the complaint, we must, of course, look at the response to the complaint. And then after I go through the response with everyone, I will take and go through the order. I'm not going through every single document in this case because ultimately it was dismissed by the courts, but so I'm just kind of hitting the most important pieces, which of course would be the complaint along with the response to the complaint. Everyone following me with that? Is it blurry? Yeah, let me know if you need a better view of this. So here we go. We've got the complaint, which I just went through. Now we will take a look at CNN's response to the complaint. It was dismissed for a lot of different reasons, and I'll go through that. I wouldn't be able to properly summarize it too quickly, so I will go through the order here shortly. We're all getting old, though, aren't we? And it's always good, of course. It's always good, of course, to look into anything that we learn. I, of course, encourage everyone to go online, pull these documents up for yourself, and take a look. I just let you know what it's saying and where it's at. You can, of course, obviously, go and find that yourself. So, highly recommend everyone doing that. So, moving on. Yes, with prejudice means it cannot be filed again. So there was a huge issue, and which I will go into. So let's get into it. Defendant Cable News Network motion to dismiss and incorporated memorandum of law. So we have the defendants coming in, and this is going to be their response here. Now, this is document 1 up here, filed October 3rd, and we've got document 20 here, which was filed November 27th. Now, just so everybody knows where we're at with the schedule here, this is the docket for this case, and it started here with this complaint. After the complaint was filed, we had notices sent out. We had a group trying to come in as pro hoc vice, which is a very popular thing to do in Florida. We've got notice of court practice on October 4th, which set out very strict rules of the format for all of the paperwork. And over here, we've got some more orders from the court regarding interested persons, another paperless order. Now we've got exhibits that were set out by Mr. Trump, in the form of attachments. Initial disclosure of certificate was also done by Mr. Trump on October 7th. A summons was returned as executed here on the complaint. So these are just procedural things, but just explaining where we are in the process. We've got a notice of attorney appearance on behalf of the cable news network here. So October 21st, notice of attorney appearance as well. A motion for appearing again pro hoc vice, which really isn't important in this particular case. Down here, October 21st, defendant's corporate disclosure statement and certificate of interested persons by CNN, identifying the corporate parent, historic. Now, we've got questions about the boss involved, so we're going to need to make sure that we follow not only the commentators, but the boss. That takes us over to a joint motion, which was asking for an extension of time for responding to the complaint. That was granted. Another order was given here for the pro hoc vice, which is really irrelevant in this case. And now we've got November 22nd, the defendant's motion to dismiss a complaint for failure to state a claim. This is where, this is the document I'm going to be talking about now. Okay, so we've got that complaint, and then the next significant thing that was filed was this motion to dismiss. Just to make sure everyone knows where I'm at here on the filings. Okay, so here we go. Let's get into this. They have some very interesting points. They've got a lot of things that they're going to need to come back. I'm going through Trump versus CNN, which was a defamation case filed last year, and I had just gone through the complaint he filed. I'm going now into the response and motion for dismissal. This was in front of the judge last year or last week, sorry. And the judge dismissed the case. So I went through the complaint. This is the response and request for dismissal. And then after this, I will go through the actual court order dismissing the case. So here we go. Page 1 of how many? That's a great question. We're going to whip through this one pretty quick. It's pretty orderly. This one is about 19 pages, but it's relaxing either way. Oh, I'm glad. I'm so glad to hear that. That is the kindest compliment. I appreciate that. All right. So pursuant to Federal Rules of Civil Procedure 12b-6, they are coming in and asking for a motion to dismiss. So typically when we have a complaint, we've got a response to a complaint, and it's typically deny, deny, deny. But in this case, the defendants came in and said, wow, there is no basis for this claim whatsoever, and the court should dismiss it as a matter of law because there's no basis. That's an interesting thing about the U.S. We can file a lot of lawsuits, but we do actually have standards for allowing that lawsuit to go forward. So if we can't, that's incorrect. That's completely incorrect. So if we can't prove that there's a basis to go forward, a judge will dismiss it. Right, and that happens a lot. So you can file whatever case you want, but it doesn't mean it'll necessarily go forward. So here we go. Our nation has long held a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. And we're citing New York versus Sullivan, which of course the complaint was asking for this to be overruled. This complaint, where plaintiff alleges CNN's coverage of him was unfair, seeks to upend this basic precept of the First Amendment law and cannot support a defamation claim. So here we go. The complaint seeks to silence any criticism of the plaintiff's debunked claim that the 2020 presidential election was stolen. The lawsuit, though, does not even try to prove this claim is true, for the simple reason that the evidence of material election fraud does not exist. Instead, relying solely on 5 CNN opinion pieces. This is an important thing to note because it's different when we're talking about opinion versus claiming facts. The complaint asserts CNN's use of the big lie to describe plaintiff's claims of election fraud conveys that he was the same character as this bad man, And 2, this description is unfair because CNN only applies the term to plaintiff out of hostile political bias. These claims are untenable and repugnant to the free press and open political debate. So it's not messing around with that. Long settled principles protecting opinion and speech related to issues of public concern require prompt dismissal under Florida law and the First Amendment. The supposed falsity of the big lie allegedly conveys that the plaintiff would be this bad man, like in future political role, and associates the plaintiff's character with that of this well-known very bad man, is unverifiable political expression. All right, so there's their defense, such that it is, and they're even saying they don't even need a defense. The big lie is a phrase wisely used by not my printer. I've printed out a lot of things lately. Not just CNN, but many journalists and the commentators to refer to plaintiffs' unfounded claims of election fraud, and any alleged association resulting therefrom are also rhetorical hyperbole and pure opinion under well-established principles of defamation law. What printer do I have? One that's been horribly abused these last few days. All right, so let's move forward. We've got a pure opinion under well-established principles of defamation law. As a further fatal defect, the complaint does not plausibly allege, much less allege with the ultimate burden of clear and convincing evidence, which is a very low, I think that's our lowest standard of proof, that CNN acted with the constitutionally required actual malice. Actual malice is an extremely high evidentiary burden for any plaintiff to meet, much less the former president of the United States of America. And he has utterly failed to meet that burden here. As this court recently recognized in the Dershowitz case, the heavy emphasis on CNN's supposed bias is irrelevant, as allegations of leftist enmity do not override the protection of the First Amendment. And we're citing this case out of Florida here. Number 2, a summary. The complaint warrants dismissal with prejudice. So we can have a dismissal without prejudice, meaning you can go and fix it and bring it back again. But we did actually have it dismissed with prejudice. All right, just hold on for 1 second. Let me double check something. I'll be right back. Okay, so had a fantastic question on the clear and convincing evidence standard here. Clear and convincing will take us beyond the preponderance of the evidence, which is our requirement for evidence in civil court, but is less than proof beyond a reasonable doubt. So clear and convincing is a middle of the road, just to make sure that I clarify that. I'm not sure exactly how I characterized it earlier, but let me be clear. Clear and convincing is more than preponderance, so more than 51%, but less than beyond a reasonable doubt. All right, back into the body of the case. I wanted to just make sure that whatever I say is factual here. So here we go. A portion of only 5 CNN publications are at issue. All right. As the complaint admits, the only statements at issue are the selected passages from the 5 CNN publications, identified in paragraph 28. As a matter of Florida law and federal procedure, the plaintiff must set forth both the details of each allegedly defamatory statement and provide notice identifying those defamatory statements before filing suit. Okay, defamation claim must set out the substance. So this is their statement. They're supporting it with law and case law here. And I'm going to flip to this next piece. Safe Pro's your jam. Oh, I love that. I love that. Thanks for keeping me on my toes. I appreciate it. The statements in the 5 CNN publications are not actionable. Now, this is really a key piece here. Oh, well, thank you. Thank you kindly. I'm not sure people in my real world would really believe my voice is that soothing, but it's very kind of you to say. All right, the crux of the complaint is CNN's persistent association of the plaintiff to this bad man and his organization through the use of the term big lie. This linchpin argument, however, does not state a claim as a matter of law, as one, the publications do not communicate nor do they plausibly convey as fact that plaintiff has the character of this bad man. 2, even if they did, they asserted association with the bad man is unverifiable and non-actionable. And 3, the complaint does not come close to plausibly alleging CNN intentionally made said association with actual malice, meaning that CNN subjectively knew the association was false or acted with reckless disregard as to its falsity. While the invalidity of this argument infects and dooms the complaint as a whole, the following roadmap shows why each publication is non-actionable. Okay, so here we go. Let's get into each point. They're going to go one by one and explain how it's incorrect. Publication A, January 25th of 2021, op-ed piece by CNN contributor Professor here, titled Trump's Big Lie Would Have Worked Without His Thousands of Little Lies, which states, "We won this election and we won it by a landslide," said Donald Trump at his Save America rally on January 6th, which incited the assault on the Capitol. This is Trump's big lie, a brazen falsehood with momentous consequences. Publication A is non-actionable because, 1, the complaint does not identify a verifiable false statement of fact. Okay? 2, big lie is rhetorical hyperbole that does not refer to this bad man or his bad organization. 3, it is pure opinion supported by disclosed and unchallenged facts. And 4, there's no plausible actual malice because no alleged fact suggests that this professor used big lie with any subjective belief that it was false. That's interesting. Okay, so publication B. One moment, please. Just, okay. Yep, we're okay at this point. Just double checking. Publication B, a July 5th of 2021 editorial by CNN editor-at-large Chris, titled Donald Trump Just Accidentally Told the Truth About His Disinformation Strategy, which does not use big lie, but instead quotes the plaintiff himself and states, "One can only hope that Trump was unaware that his quote was a near replication of this infamous line from this very bad man. If you tell a lie big enough and keep repeating it, people will eventually come to believe it." Now here's the support. Publication B is non-actionable because the term big lie is not used. Okay? 2, the complaint has not identified a verifiable false statement of fact. Okay? It's not defamatory, and not defamatory meaning it's true, and it merely compares 2 quotes. So that is the support then for publication B. Now publication C, a September 15th of 2021 editorial, again by this person, titled Donald Trump's Mental Health Becomes an Issue Again, which states, Trump has A, never conceded the 2020 election to President Joe Biden, and B, continued to push the big lie that the election was somehow stolen, despite there being zero actual evidence to back up that belief. Publication C is non-actionable. And of course, if it's non-actionable, that means there can be no recovery. That means there can be no part of that. Now, beige, I'm going to need you to calm down here. This is going to serve as your warning, but I'm going to need you to calm down a little bit, please. I don't need those kinds of energies in my world. So if you could just take a step back, would be much appreciated. Publication. All right. Let me see. Where was I? I was so intent there. All right. A, the complaint does not identify verifiably false statement of fact. Right. It's rhetorical hyperbole and does not. Okay. I'm sorry, but that is just not going to be going on here. So one moment, please. Thank you. As I give my nod to my moderators who are working hard, I will need to make sure to thank them properly. All right. 3, it is pure opinion supported by disclosed and unchallenged facts. And 4, there's no plausible actual malice because the complaint contains no facts suggesting that he used big lie, believing it to be false. And again, this is a really important piece when you're trying to go forward on malice and the malice element required for a defamation suit. So there's our third publication and all of the reasons why it is not defamation. Now we go on to publication D, on-air statements by CNN host Jake Tapper during the January 16th of 2022 telecast of CNN's State of the Union program, in which Mr. Tapper states, Tapper, over the weekend, while Martin Luther King III was in Arizona rallying to expand voter rights, Donald Trump was the same day in the same state doing the exact opposite, continuing to push his big lie. And then there's a video clip. Trump, last year we had a rigged election, and the proof is all over the place. They always talk about the big lie. They're the big lie. End of video clip. Tapper, there's a reason Trump was in Arizona to push the legislature to disenfranchise the state's voters based on all of his deranged election lies. Flipping the page, so let's see what they've got for support to say that this publication D was false or was not actionable as defamation. Number 1, there's no identifiable, verifiable false statement of fact, right? 2, the terms his big lie and deranged election lies are rhetorical hyperbole and do not refer to a specific bad man or his specific bad organization. The use of those terms is pure opinion, and there's no plausible actual malice because the complaint contains no facts suggesting Mr. Tapper used big lie, believing it to be false. Next, we've got publication E, and this is the last one that they're citing here. They're saying there were 4 publications. Okay, hold on. Again, taking an opportunity, I am absolutely fine with our political discussion here, but blatantly false statements will not be tolerated by any of my moderators. So you'll have to put those falsities on someone else, on someone else's TikTok. All right, here we go. Publication E, the third editorial from February 11th. Here's the terrible reality. Trump's election lie is on the march. Which states by now you know about Trump's big lie? It's that the 2020 election was somehow fraudulent, that Trump actually beat Joe Biden, but that through widespread voter fraud, and the result didn't reflect the will of the people. It is non-actionable because yeah, thank you. Okay, listen, one more minute. You are all giving my moderators here a run for their money. False statements are not permitted here. Political discussions and opposite opinions, of course, but completely false statements are just not permitted. So there's no identified, verifiable false statement of fact is the number 1 piece. And that seems to be what they're relying on heavily here. So 2, the term big lie is political invective and does not refer to this bad man or his organization. The use of big lie is pure opinion. And there's no plausible actual malice because the complaint contains no facts suggesting that he used big lie, believing it to be false. So there you go with that. And that, again, those what are false statements? And that's a standard that we use when it comes to defamation. We have to show that the statements were false. So, of course, the true defense to defamation is the truth. So if they're true statements, then they're not part of defamation. And the way that they're saying that legally is by saying that they're not false. So we're not really using that term truth, because that is a very difficult term when it comes into the legal world. So we're using that phrase, not false. Oh, well, that's okay. Nay, don't worry. I'm very careful about my guidelines here, and I also have some great moderators going on. So I'm just doing my best. I make sure I'm always within the guidelines. So I'm just being very careful. Number 3, the allegations and legal theory of the complaint. How do they know what content to pull from the articles? This is all direct responses to exactly what was set out in the complaint by Mr. Trump. So this is exactly a response to each one. So he set out multiple complaints, and they're going back through with each one of those complaints and setting out the facts behind it. What do I believe personally? I believe the court records and the legal findings. So that's where my stance is. So the complaint asserts 2 claims, count 1 for defamation per se, and count 2 for defamation. Intertwined with both claims is plaintiff's overarching theory of falsity, that the big lie create a false and incendiary association between the plaintiff and this bad man when describing the plaintiff's claims about the integrity of the election process for the 2020 presidential election. The complaint asserts big lie is a statement of fact that conveys the plaintiff would be like this bad man in any future political role, and associates plaintiff's character with that of this bad man. The complaint does not explain anywhere why that allusion is false. All right. As stated, the defamation claim is solely based on passages from 5 publications, some using big lie and some not. Each is obviously opinion in label, tone, and content, and they're citing law here. And the complaint does not identify any specific falsity in cited passages. Yes, I wouldn't say necessarily censored words, but I am, this is certainly not my app, and I do respect and follow the rules set out in the forum that's allowing me to present this information to everyone. So I am trying to be respectful of those rules in every way that I can, and would hope the rest of you would also be respectful. Again, this is not my house, so I am a guest in the TikTok house. So here we go. As stated, the defamation claim is solely based on passages from 5 publications. All right, we've already gone through that. Nothing specific. So the complaint admits plaintiff is a public figure and contends the allegations meet the actual malice standard because CNN knew the association of plaintiff's character with that of this bad man was false, or CNN published the statements with reckless disregard for their truth or falsity. The complaint, however, offers no fact suggesting CNN subjectively doubted the truth of the identified passages or use of the big lie. Yes, as applied to plaintiff's conduct, instead plaintiff asserts CNN is politically biased against him based upon disparate treatment of political figures who support its narrative versus those who do not, on claims of election infirmities, and that CNN's reporting is propaganda and self-serving pronouncements by political opponents of the plaintiff and their news proxy and political participant, CNN. The complaint also cites a 2012 telecast in which then CNN political director Paul Steinhauser states that comparing members of the Republican Party to a bad group is not cool, stupid, and sick. All right, I don't think I made that a connection that it was in 2012, so that's new information. Just one moment here. And a June 2022 report, many months after the publications were published, in which CNN's chairman and CEO Chris Licht reported, expressed displeasure with the use of big lie. Such allegations, even if true, are dispositive and of absolutely nothing. Right, so that's how that went. Okay, again, taking a moment out to say to everyone, I am absolutely fine with political discourse, but false statements are not permitted here on this chat. I do have moderators in place and am being careful myself, so please be respectful of that. Again, I will not... I have to take time out away from everyone else here to double check on this. I am going to absolutely not allow for a complete false. If we've got questions, that's one thing. But if we're just trying to put false information out into the chat, that's not permitted here. So you have to kind of go somewhere else for that, which is, your prerogative. So... okay, yes. All right, back to it. So a summary. I am going through, slowly but surely, the response to the complaint that was filed by Mr. Trump against CNN. And this was for defamation for certain pieces of articles and segments that were done. And so because of that, he filed a defamation case. Now we are going through the response and the request for a dismissal. Now, this case was filed last October. This is a response done in November. And then just Friday, a couple of days ago, a judge dismissed the case. So this is the motion for dismissal that the judge approved on Friday. So that's a quick summary. Now let me try to get back into this because I think we really need to make sure this information is factual as best as I can make it. So there we go. We've got this discussion of the actual dates that they cited because this is the evidence that they used to show defamation. So we've got legal standard next. Plaintiff must plead enough facts to state a claim to relief that's plausible on its face. And this is essential. You've got to make sure you're pleading enough facts. And so I believe they're going to go into the argument that not enough facts were set out. So let's see what they've got. Construing all allegations in the plaintiff's favor. And they're citing key 11th Circuit case law, which is where the case is being filed here. However, this court need not accept conclusory allegations or legal conclusions, which I think anyone in the legal community would understand. There were a lot of conclusions in the complaint, and that's, I think, what they're claiming here. The court's review is generally limited to the four corners of the complaint. Here's our Dershowitz citation. But it may consider material that's referred to in the complaint as essential or integral to plaintiff's claims. Florida provides the substantive state law for plaintiff's defamation claims as plaintiff resided in Florida at the time of the publication at issue. Florida requires public figure plaintiffs to satisfy 5 elements. So this is the standard of law And what they're doing is they're saying the complaint did not meet the standard of law. So let's take a look at the elements that are required in order to go forward on this. Florida requires a public figure plaintiffs to satisfy the 5 elements. 1, publication. 2, falsity. I don't think we have any issues with publication. 2, falsity. Now that's an issue. 3, knowledge or reckless disregard as to the falsity, and they've raised that again under each of those different documents. 4, actual damages, and 5, a defamatory statement. So there are lots of pieces to this that have to be pled out in your complaint. A false statement of fact is the sine qua non for recovery in a defamation action. Now, moving into the next piece, we've got the First Amendment also requires that public figures plausibly allege an actual false statement of fact about the plaintiffs that is, 2, susceptible of being proved true or false, and 3, made by the defendant with actual malice, that is, with knowledge that it was false or with reckless disregard of the falsity. These are the legal standards in order to go forward on a defamation case. Now, here's the argument set out by defense counsel. Argument and citation of authority. The complaint uses the same flawed theory of falsity and actual malice across all the publications. CNN accordingly addresses why plaintiff's defamation theory fails generally, and then summarizes why each publication cannot support a defamation claim. A, plaintiff's overarching theory of falsity fails as a matter of law. As discussed above, plaintiff's theory of falsity is narrow. Plaintiffs contend the big lie falsely conveys as fact the plaintiff's character can be associated with that of this bad man, and that the plaintiff would be this bad man like in any future political role. The court must therefore determine whether the big lie plausibly conveys a false statement of fact and grant dismissal if it does not. Of course, we are doing not only a response to the petition, but we are also doing a motion to dismiss at the same time. Number 1, sub 1, the complaint does not plausibly identify a false statement of fact. So let's see what they have to back that up. First, nowhere does the complaint actually allege a specific false statement of fact in the publication. And that's pretty detrimental. That's a pretty detrimental piece if it's found to be true. This lack of falsity is glaringly obvious in publication B, which does not even use the term big lie. Instead, this person merely compares a quote by the plaintiff with a quote from another bad person, and yet neither quote is alleged to be inaccurate. Simply put, there's nothing false at all in publication B. It is merely a comparison of quotes. The plaintiff in this case is Donald Trump. The defendant is CNN. Further, plaintiff's overall theory of falsity for the big lie is implausible, and the complaint should be dismissed for this reason alone. Plaintiff does not contend big lie is false. Now, before I move on, let's just look and see what they're citing for that. And they're citing a case, a Florida case decided in 2008 in order to come up with defamation by implication standards. Yep. There's the footnote right there. Let me actually just pull this case out of all of this language so you can pull that case up if you're interested in it. They're also citing the Corsi case. This is another Florida case, and the Jacksonville Kennel Club case. So this is where they're citing their standard for what is needed to prove falsity in a defamation case. You bet, of course. Next, moving on, let's go into on its face. He instead relies on 2 inferences to construct an artificial falsity. 1, big lie is understood by readers to refer to propaganda tactics espoused by this bad man. And 2, thus readers understand big lie asserts as fact that plaintiff has the actual character of this bad man. Plaintiff, however, cannot build inference upon inference in order to find defamatory meaning in a statement. And this is a very famous case that set out those kinds of questions as well. And we had, although I believe this case is a California case, but still it's got those essential elements when it comes to defamation. Oh, absolutely, absolutely. I mean, we've got to just look to the facts and the language. Yes, I think it has. My moderators are so good. Thank you, moderators. Okay, so citing when this very bad man and this phrase in reference to the Church of Scientology did not mean church promoted this type of activity. So that's what that case is about. It's actually a very interesting case. Both inferences are implausible. In the context of these specific publications, average readers would not plausibly understand Big Lie to be an allusion to this bad organization as opposed to a lie that is big. And we're citing again case law here to back that up. And more case law here. Moreover, average readers would not plausibly conclude that these specific publications assert plaintiff actually has the character of this bad man, or would literally be like that bad man in any future political role. Even if these inferences were plausible, the complaint does not explain what is actually false about the alleged historical allusion. Okay? As such, plaintiff's attenuated theory of falsity does not identify a plausible false statement of fact warranting dismissal. And we are citing this case here. It's a 2001 case. Perhaps. So let's flip to the next page here. The second part. Plaintiff seeks to impose liability for unprovable statements. Plaintiff's theory of falsity also fails under the First Amendment, as it explicitly relies on an unprovable proposition, whether the plaintiff will be this bad man in any future political role, and whether his character can be associated with that of this bad man. Statements that are not susceptible for being proved true or false are absolutely protected by the First Amendment. That is a really essential piece when we're doing any kind of defamation case. So I'm going to just kind of pull that out because that quote is so important. We have to have this standard met in order to go forward with defamation. The provable falsity requirement ensures that free debate is not curtailed, as otherwise liability could be based on speculation and a jury's approval or disapproval of the contents of the statement, its author, or its subject, rather than on the truth or falsity of the statement. Thus, terms that are debatable, loose, and varying or suffer from tremendous imprecision in meaning and usage in the realm of political debate are not actionable. Another piece. Yes, it's important if I've got the highlighter out. Yes, so the key here is statements that are not susceptible for being proved true or false are absolutely protected by the First Amendment. That's really an essential piece to this entire issue of defamation. So, such protections are critical in matters involving, as here, core political speech concerning the integrity of a presidential election. Okay, I'm going to just take a moment here just to check in on everybody. So calling someone mean, immortal, etc. can't be considered defamation for a public political figure. I think it could be, Jenny. I think the point that they're making here is with regards to a specific person. That was really the issue in this case. So I think that's really the question. I think those issues of immorality, of course, can be part of defamation. But if we are trying to compare a particular historical figure to a current person, then those kinds of issues are not something that can necessarily be proven one way or the other. So that's what they're arguing, is to make those kinds of comparisons are allowable under the First Amendment. There is no quantum of proof that can prove or disprove speculative conjecture on whether plaintiff will be like this bad man if elected to office again, or whether plaintiff's character can be associated with that of this bad man. Such conclusions are subjective assessments of the intangible, a perception of whether one's mental or moral qualities, based on the conduct and statements, align or do not align with the mental or moral qualities of historical figures. And then we've got case law cited here. Just as in the Ullman case, so prior precedent, where a plaintiff who was said to be an outspoken proponent of political Marxism, and in the Buckley case, where the plaintiff was accused of overtly being fascist and part of the radical right, so too here. Plaintiff's allegations that he's being likened to a bad man or accused of being like the bad man intentions does not identify a provable false statement as a fact as a matter of law. Right, exactly. Yep, you got it. Instead, whether plaintiff's character is bad man-like is simply an idea, and there is no such thing as a false idea. However pernicious an opinion may seem, we depend on its correction, not on the conscience of judges and juries, but on the competition of other ideas. And we're citing a U.S. Supreme Court case here. Number 3, plaintiff seeks to impose liability for protected political rhetoric. Next, any bad man-like comparisons flowing from the big lie and deranged election lies are all protected rhetorical hyperbole, and the First Amendment provides protection for statements that cannot reasonably be interpreted as stating actual facts about an individual. And we're again citing case law here. Let me just double check what we've got going on. Just keeping my eye on everybody. I don't want to miss anybody's question, although I'm sure I will, but I will try my best. So here's our citation. Protecting such terms ensure that public debate will not suffer for lack of imaginative expression or rhetorical hyperbole, which has traditionally added much to the discourse of the nation. Again, citing the Milkovich case. This is because exaggeration, political invective, and rhetorical language used for dramatic effect in a heated public debate are not assertions of literal fact. We've got another citation here, and they're pulling this out of the Levinsky case, which is down here, just for anyone who's interested in the case law supporting that up. As used in the publication, big lie and any resulting comparison is simply a rhetorical flourish for dramatic effect in a heated debate on a topic on which there should be no wider latitude for speech. The integrity of the 2020 presidential election. Indeed, courts have protected language considerably more direct and laden with specific meaning than an inference of being like this bad man, such as a fascist, or of this word and this word. And they're citing case law here. For example, in publication A, this professor's op-ed clearly uses big lie to make a political point. A big lie is an alternate belief system dependent on smaller lies, and it is the authoritarian way. This does not state a literal fact that the plaintiff is this bad man or will literally implement policy programs from this bad group. Instead, publication A uses big lie as an expression of contempt for plaintiff's conduct. Thus, big lie is the same as loose language or undefined slogans that are a part of the conventional give and take in our economic and political controversies, like unfair or fascist, and is not a false statement of actual fact. So such rhetorical allusions to history are not actionable, which I think they said multiple times. So we've got this idea that he's saying, we've got history here that we're comparing it to, and so we're not going to be able to find an actionable claim in that situation. All right, number 4, plaintiff seeks to impose liability for non-actionable pure opinion. Again, if we've got non-actionable opinion, we don't have cases for defamation. Next, the complaint fails because according to plaintiff's own theory of defamation, the term big lie is pure opinion and is protected under Florida law and the First Amendment. Opinion under Florida law is a critical judgment made by the author. Pure opinions are opinion statements accompanied by recitation of facts on which the opinion is based or the underlying facts are commonly understood by the public. This is a response. Yes, this is a response from CNN to Mr. Trump's complaint that he filed for defamation. Mixed opinion implies the existence of other undisclosed defamatory facts. Whether a statement is one of fact, mixed opinion, or pure opinion is a question of law and is judged based on the totality of the publication. And then we'll skip down here. Big lie is pure opinion. In the 4 publications using the term, big lie is a critical judgment based upon 2 disclosed unchallenged facts. So we've got facts, we don't have defamation. 1, plaintiff claims that the 2020 presidential election was rigged or stolen through material fraud. And 2, there's 0 actual evidence and no proof to validate those claims. These facts would be known to the reader either through the publications themselves or because they were already known to the public given the extensive news coverage surrounding the 2020 presidential election. CNN's coverage of plaintiff's claim of electoral fraud and the scores of judicial decisions rejecting such claims. Further, because these underlying facts were explicit, there is no implication that the reported statements that there were undisclosed facts, which also form the basis of the author's opinion. So again, we're really arguing here, are we talking about facts or are we talking about opinions? And if we've got facts and true facts, that is the ultimate defense to any defamation. The complaint does not challenge any of these underlying facts. Big lie is pure opinion. And if we've got opinion, then we're not going to be dealing with a defamation situation. Finally, any message conveyed by big lie suggesting plaintiff is or will be like this bad man is also necessarily pure opinion. Plaintiff complains about critical judgment that he has the character of this bad man, which is based on explicit, disclosed, and unchallenged facts. Plaintiff cannot validate his claim that the 2020 election was rigged or stolen. As such, the big lie implies that plaintiff has a character like that of this bad man. Such message is nothing more than commentary on the facts presented. So yes, everyone, let's be respectful in the chat, please. My poor moderators are probably exhausted at this point. So let's bump down to B. The complaint does not plausibly allege actual malice. Plaintiff also does not plausibly allege CNN used the phrase big lie with actual malice as required by Florida law and the First Amendment. To plausibly allege actual malice, plaintiff must identify specific facts giving rise to a reasonable inference that CNN subjectively actually entertained serious doubts about the factual accuracy of the publications or that CNN was highly aware that the publications were false. Yes, they have a lot of opinions. That's exactly it. And opinions are something that is pretty well protected by the False Amendment. And they're citing case law here. This is the Michael and the Gertz case. I won't go into too much explanation about those because I am trying to kind of get through here so we can get to the actual opinion of the court. So plaintiff must therefore allege facts showing CNN in fact entertained serious doubts about using the term big lie in reference to plaintiff's election fraud claims. Knew big lie inaccurately compared plaintiff to this bad man and intended such a comparison, citing case law again regarding the requirements for defamation. The complaint does not and cannot meet the standard warranting a dismissal, and so that's what they're asking. So not only are they responding, but they are asking for a motion to dismiss in this particular situation. Paul, you get muted when anybody can get muted, and that's because false statements are not permissible here. And I've got some mods very carefully watching out for that. If you have something to say that everyone or anyone disagrees with, that's absolutely fine. But false statements are not permitted here. They're just not. There are other places for that. And in this particular situation, I've just had about enough of that. So do I record these lives? I do. They are recorded, and then I go and put them onto a different channel. So you can listen to them once they're posted if you are interested in that. Yes, and I'm just giving you literally black and white information here that's been filed with the court. So opinion-wise is not something that I'm doing. I'm just putting out this information. So let's move on here so we can get a little bit further. And they're going again into how the complaint had a circular claim, which I think we can all make that decision. Without evidence is a crime. Correct. That's correct. Although we are in civil court talking about defamation here. Circular claims of actual malice must be disregarded. For example, it's not enough that the complaint alleges CNN knew the association of the plaintiff's character with this bad man was false, or they published the statements with reckless disregard for the truth or falsity. Similarly, the complaint contends CNN repeating inflammatory language demonstrates actual malice because it is repeated or inflammatory. This is not only conclusory, but also circular. Neither allegation shows CNN subjectively doubted the truth of the big lie. And again, we're citing case law here. Yes, it was dismissed. And I'm just about there. I'm just about to the court's decision here. So almost there, still finishing up this response to the complaint. Second, the complaint does not allege any facts showing the state of mind of anyone at CNN responsible for the publications. 2, allege any facts showing CNN doubted the truth of any specific passage in any publication. Or 3, connect CNN's generally averred knowledge of falsity to any specific publication. For example, the complaint does not allege facts suggesting that Mr. Tapper doubted his characterization of the plaintiff's claim of election fraud as big or deranged election lies. The lack of any facts showing any author's state of mind at the time of publication dooms the plaintiff's claim. That is an essential element of defamation. Okay. Let's make sure that we're not putting out any facts that cannot be proven here in our chat. Opinions are fine, but let's just keep it on the up and up. Thank you very much. And then bumping down here, third, plaintiff's allegation that CNN is treating him unfairly because it is politically biased against him does not plausibly allege actual malice. That's a good point. You have an excellent point there as well, especially with the technology that we have right now. The complaint takes issue with CNN's reporting on other Democratic politicians' claims of election infirmities, contending that none of these individuals were accused of propagating a big lie or even lying, which allegedly is a clear indicator of CNN's malice. The complaint further argues that actual malice standards should not apply at all because CNN is not publishing statements to foster debate, critical thinking, or the unfettered exchange of ideas, but rather seeks to participate in the political arena. So let's see, this actual malice theory is simply not supported by any law. As this court recently, and again we're in Florida, so keep that in mind, recognized the allegations of leftist enmity cannot trump the guarantees of the First Amendment. And this is the Dershowitz case. Plaintiff's allegations that CNN was motivated by political animus cannot serve as proof of actual malice. To the contrary, such allegations are immaterial to the claim and are an impertinent salvo that do not belong in the case. Finally, the complaint's passing reference to statements by various individuals at CNN long before or after the publications were published do not even begin to reasonably show that CNN doubted the veracity of the publications. First, statements by former employees such as Ms. Banfield and Mr. Steinhauser in 2012 do not and cannot demonstrate CNN acted with actual malice in 2021. Using big lie to describe plaintiff's claims of election fraud, particularly as to a 2012 telecast, did not address plaintiff or his claims of election fraud at all. Likewise, the alleged report that CNN's then new chairman reportedly expressed displeasure of big lie and explicitly instructed CNN anchors to stop using the phrase the big lie is not evidence of actual malice. Not only is this displeasure an editorial preference, rather than an expression of subjective doubt, the meeting occurred months after the publications were published and does not indicate anyone thought big lie was factually false. In sum, the complaint does not plausibly allege that CNN entertained any doubts about the publications. Dismissal is therefore warranted. And then we're citing the 11th Circuit here. Can I do the Mueller report next? Oh my goodness. Oh my goodness. I'll have to think about that. I don't know. I've already got a lot of agencies keeping an eye on what's going out into the public, so I'm not sure. I will have to I'll have to think about that. All right, this court should follow suit and dismiss the complaint. Now C, we're getting into the very final pages here. So we've got 1, 2, 3 pages left, and then we will be into the judicial order. Oh my gosh, run-on sentences, yes. Whoo! Yes, I do. I actually have a print of the Mueller report, and so that's why I laughed. That would have to be a multi-day series. Goodness. Okay, so, and of course I printed it out because I had to read what was actually said, not just summaries. All right, the publications are individually not actionable. In summary, CNN will demonstrate each of the 5 publications is not actionable. One publication, Trump's big lie, wouldn't have worked without his thousands of little lies. It was published under CNN Opinion and authored by this professor, a frequent contributor to CNN Opinion. The article identifies plaintiff's big lie as we won this election and we won by a landslide. Publication A contends this claim is a brazen falsehood by pointing to these facts. Plaintiff lies about dead people voting, about fraudulent mail-in ballots, about votes illegally counted, not counted at all, or invented, falsely accused Democrats of pulling suitcases of ballots out from under a table, and lied that news media had declared Biden the winner, even though they still don't have any idea what the votes are. In context, big lie is a pure opinion in a piece that is obviously opinion in label, tone, and content. Citing case law here, it discloses the facts on which big lie is based and does so in a polemical, I may have been talking for too long, in a polemical, highly opinionated manner. The use of big lie is clearly rhetoric used to make a point. Lying about an election is authoritarian in nature. To the extent big lie draws comparisons to this bad man, it is not verifiable. Finally, plaintiff does not allege facts that suggest that this professor used big lie with any subjective belief that it was false, as is required by this case law. Number 2, publication B. Donald Trump just accidentally told the truth about his disinformation strategy. Publication B is an analysis piece by this person, a CNN editor at large, and published on CNN Politics under The Point. In label, tone, and content, it is obviously opinion. This person quotes the plaintiff as stating, "If you say it enough and keep saying it, they'll start to believe you," and then states, "One can only hope that Trump was unaware that his quote was near replication of a quote by this bad person." In short, this author compared a statement from plaintiff against statements by this bad person, correctly conveying both quotes. There is nothing defamatory here. There's nothing false here. The article does not even use the term big lie. Plaintiff does also does not allege facts that suggest that Mr. Writer made any statement with any subjective belief that it was false. It is non-actionable. Now, at this point, I'm going to need to pause just for a moment. Thank you. Oh, my goodness. I'm checking on my heat source here just to make sure. I'm going to just kind of summarize 3 and 4 because I do want to make sure I get the court order in here before I close the live for today. So let me summarize these last couple of pieces. 3, publication C, Donald Trump's mental health becomes an issue again. Now, again, they're saying the same thing. The article and statement are pure opinion. The factual premise for using that is identified. The factual premise is not challenged as false. Key elements again. So, B, publication D, the State of the Union. This that aired. It's a Sunday morning talk show with commentary from a host on the show. Rigged election, a big lie, deranged election lies. It's obviously opinion commentary again, and they're supporting that here with case law. Publication E, here's the terrible reality, and yet again, no alleged false statement of fact about the reference. It's pure opinion, and then that bumps us down to conclusion. So to summarize, we've got 3 separate points that were opinion, therefore we're not going to fall under the defamation umbrella. Yes, oh, Galaga, of course. Love Galaga. Okay, 6, conclusion. The complaint should be dismissed with prejudice. And that was the request, and now we've got the certificate of service. So that is a summation then of the very last couple of pieces of the response and the motion to dismiss. So here we go. I've done the complaints from Mr. Trump against CNN regarding defamation. I've done the motion to dismiss and the counter arguments. So let's go in finally then to the order that was issued by the court on Friday. And let's look and see what the court has to say about all of this. And they come in and citing all of their sources. So this was just filed on July 28th out of the U.S. District Court, Southern District of Florida. So here we go. We've got the order. This cause is before the court on defendant Cable News Network. Motion to dismiss, which is what I just read. The motion is fully briefed and ripe for review. For the reasons discussed below, the motion to dismiss is granted. So let's look at the court's analysis. Checking my heat source. I was checking my my phone gets a bit hot after a certain period of time. So just checking to make sure I'm okay for all OSHA purposes here. All right, so here we go. Introduction. And this order goes pretty quick. Plaintiff Donald J. Trump is a former president of the United States of America and a citizen of Florida. Defendant CNN is a news media corporation organized and incorporated under the laws of Delaware, as most companies are, with its principal place of business in Georgia. Trump has sued CNN for defamation, alleging diversity citizenship. So this is what's allowing the court to hear the case. Trump alleges CNN defamed him by making statements comparing him to a bad man and a bad regime. Trump's complaint specifies 5 instances of alleged defamation. And so the court goes in and quotes those specifically. I won't read through those again. I think I've done each of these multiple times. So that takes us, these are all of the allegations again. In the instances, those 5 instances, chat the screen if you'd like, Galaga. Oh, yes, Galaga's fun. Here we go. Trump alleges that the use of the phrase, the big lie, constitutes defamation per se because it creates a false and incendiary association between the plaintiff and this bad man. He argues that the use of the phrase, the big lie, is defamatory because it has incited readers and viewers to hate, contempt, distrust, ridicule, and even fear the plaintiff, causing injury to the plaintiff's reputation, and the plaintiff's political career. As a result, Trump claims the viewers and readers understood plaintiff would be like this bad man in any future political role. So let's see what the court has to say about that. Trump further alleges that CNN failed to similarly challenge Democrat politicians who complained about election integrity. He argues that CNN's disparate treatment of public figures is evidence of malice and evidence that defendant is not reporting the news, but rather propagating its political views. Trump seeks damages in excess of $75,000. So those are the compensatory damages, punitive damages in the amount of $475 million, pre- and post-judgment interest, taxable costs, and trial by jury. CNN moves to dismiss the complaint with prejudice. So let's look at the legal standards. A motion to dismiss. To survive a motion to dismiss, factual allegations must be enough to raise a right to relief above the speculative level and must be sufficient to state a claim for relief that is plausible on its face. This is the standard out of the U.S. Supreme Court here in 2007. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And this is under the Ashcroft case. The mere possibility the defendant acted unlawfully is insufficient to survive a motion to dismiss. So this is the standard. You've got to push past this in order to go forward on your case. We actually do have rules that we have to follow in order for a case to proceed in court. And we've got also the Muhammad case that's mentioned as well. In considering Rule 12b-6, a motion to dismiss, the court's review is generally limited to the four corners of the complaint. So they're saying we're specifically looking to the complaint. The court must review the complaint in the light most favorable to the plaintiff, and it must generally accept the plaintiff's well-pleaded facts as true. So that's an interesting point a lot of people don't realize. The court looks at the complaint and they look at it in the light most favorable to the plaintiff. By conclusory allegations, unwarranted deductions of fact, or legal conclusions masquerading as facts will not prevent dismissal. Defamation. So let's get into what the court is holding here. The parties agree that Florida law applies to this dispute. In Florida, a defamation claim has 5 elements. 1, publication. 2, falsity. 3, actor must act with knowledge or reckless disregard as to the falsity on a matter concerning a public official, or at least negligently on a matter concerning a private person. And 4, actual damages. And 5, a statement must be defamatory. And this is based off of case law here. A claim of defamation requires a false statement of fact. A false statement of fact is a requirement, the absolute necessity for recovery in a defamation action. Statements of pure opinion are not actionable. This is really a key element, because if we only have statements that are opinions, we're not looking at a defamation situation. The distinction between fact and opinion is not always easy to perceive. Thus, the law recognizes that some comments may be pure expressions of opinion, whereas others may be a mixed expressions of opinion. Whether a challenge statement is one of fact or opinion is a question of law to be decided by the court. When applying state defamation law to public figures, the First Amendment imposes additional limitations. The statement in dispute must be sufficiently factual to be susceptible to being proved true or false. Next, the statement must be actually false. And finally, again, these are the rules for defamation. A statement must have been made with actual malice, that is, with knowledge that it was false or reckless disregard, or whether it was false or not. And we're quoting New York Times versus Sullivan. Thus, even if the statement is made with bad or evil intent, it is not actionable under the law if it's pure opinion. And this subsection, or this citation, bumps us down to an extra piece that the court is citing. Trump asked the court to reconsider New York Times versus Sullivan. The court is unable to do that. The case is legally binding on the court. So this idea that the New York Times v. Sullivan standard should not apply to this case, the court just flat out rejects it and says it's unable to do away with that standard that was set out by the U.S. Supreme Court in the 1960s. So here's our discussion. This case involves political speech of the highest order. The First Amendment has its fullest and most urgent application precisely to the conduct of campaigns for public office. As a panel of the 11th Circuit recently stated, the First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Accordingly, speech on public issues occupies the highest rung on the hierarchy of the First Amendment values and is entitled to special protection. Speech involves matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of general interest and of value and concern to the public. So we've got a specific setting out of what that First Amendment mean. Does a judge have to know case history to judge? Where do judges get citations? Well, we all learn about the basics when we're in law school, of course, and then we kind of keep our own way of keeping our sets of cases straight. So they've got their own techniques, but there's just certain basic legal principles that we all have. Our judges also have something called a bench book, which sets out a lot of that key landmark case law for each jurisdiction. So whatever state you're in, a judge will have a bench book regarding particular issues. So that's kind of how that is set out. The contested speech in this case involves reporting and commentary on Trump's challenges to the legitimacy of the 2020 presidential election. There is no question that the statements made by CNN meet the publication requirement for defamation under Florida law. So that first element is met. The next question is whether the statements were false statements of fact. This is where Trump's defamation claims fall. Of course, as we all know, the truth is an absolute defense. Oh, sure, absolutely. The problem is essentially twofold. First, the complained of statements are opinion, not factually false statements, and therefore are not actionable. That's important. Second, the reasonable viewer, unlike when Sullivan, this case, or Gertz was decided, no longer takes the time to research and verify reporting that often is not, in fact, news. So we have this kind of line being drawn here between when we need to have opinions that's being set out by a news source versus news, and being able to make that distinction between factual news versus opinions. As an example, only 1 month ago, the United States Supreme Court issued a well-written 237-page joint opinion with vastly divergent views in two cases known widely as the affirmative action decisions. I think we all know what those are. Within minutes of the release of the opinion, the Free Press had reported just what the opinion supposedly said and meant, although it was clearly impossible that the reporter had read the opinion. You know, as a quick side note, as someone who reads everything word for word, I would agree with that. I'm not sure how the reporters get their stories out so quick because it's impossible to read an opinion that huge that quickly. So I'm just saying, as a quick side note, absolutely true. And of course, those initial news articles were repeatedly shared, commented upon, and disseminated over social media. And still to this day, the reasonable viewer very likely hasn't read the opinion, unless you join me here on TikTok, and then you probably have, and never will. This is the news model for today. It is a far different than that in Sullivan, which altered law that existed 175 years ago and has spawned a cottage industry over the last 60. But this too is not actionable. That's bold. Oh, thank you for the flowers. Appreciate that. Trump argues that CNN's motivation for describing his election challenges as the big lie was to undermine Trump's political standing. But political motivation does not establish falsity. The intention to portray a public figure in a negative light, even when motivated by ill will or evil intent, is not sufficient to show actual malice unless the publisher intended to inflict harm through knowing or reckless falsehood. And that's supported by a lot of case law as well. Acknowledging that CNN acted with political enmity does not save this case. The complaint alleges no false statements of fact. Trump complains that CNN described his election challenges as the big lie. Trump argues the big lie is a phrase attributed to a very bad man, and that CNN's use of the phrase wrongly links Trump with another extremely bad man regime in the public eye. This is a stacking of inferences that cannot support a finding of falsehood. Next, we've got, they're citing the Church of Scientology case, which is a landmark case on defamation. This case is similar to the present case. There, a city official made numerous public statements opposing the church's presence in the city. In one, he stated, this is a direct quote, "Scientologists are bringing to the city a bad world and philosophy." The church sued, stating that the term that was used had, by reason of best-selling book and television movie of the same title, come into public understanding as descriptive of the policy of a generation of racial strife and indiscriminate mass murder allegedly espoused by the infamous and widely publicized Mr. Bad Person here. The church claimed that by using this particular term, the defendant intended to convey to the public that the church was dedicated to promotion of a generation of racial strife and indiscriminate mass murder. The former Fifth Circuit found no defamation, stating that it was not prepared to build inference upon inference in order to find defamatory meaning in the statement. Neither is this court able to create an inference of defamatory meaning. Just pausing for a moment. Right. Trump alleges that the big lie refers to a particular kind of propaganda campaign, terrible, awful propaganda campaign to justify Jewish persecution and an awful, awful thing that occurred. Like Trump and CNN personalities, these two people, the court finds that references to this horrible regime in the political discourse made by whichever side to be odious and repugnant. But bad rhetoric is not defamation when it does not include false statements of fact. That is an essential piece here. So we're going to get the big highlighter out. CNN's use of the phrase "the big lie" in connection with Trump's election challenges does not give rise to a plausible inference that Trump advocates the persecution and genocide of Jews or any other group of people. No reasonable viewer could or should plausibly make that reference. And then we're citing case law here as well. And even if the phrase "the big lie" could somehow plausibly compel a reasonable viewer to perceive Trump as like this awful man or authoritarian, such terms are not statements of fact subject to defamation laws because of the tremendous imprecision of the meaning and usage of such terms in the realm of political debate. A connotation or implication is only actionable if it is provable false. And that's a key point too. Being like this awful man is not a verifiable statement of fact that would support a defamation claim. Trump argues that a motion to dismiss is not the proper avenue for evaluating the defamatory nature of CNN's comment. The court disagrees. Whether the defendant's statements constitute defamation is a question of law for the court to determine. And we're citing case law to support that. Whether the publication is defamatory becomes an issue of fact for the jury only where the publication is susceptible of two reasonable interpretations, one of which is defamatory. CNN's statement, while repugnant, were not, as a matter of law, defamatory. The case will therefore be dismissed with prejudice. Accordingly, it is hereby ordered and adjudged that CNN's motion to dismiss is granted. Plaintiff's complaint is dismissed with prejudice, and the clerk of court is directed to close this case and deny as moot any pending motions. Done and ordered, the 28th day of July of 2023. So there we have it. We've got the full dismissal then of the case. There's no factual basis to go forward for a defamation claim. All of the statements that were made, although clearly repugnant and offensive, are opinion statements that are protected by the First Amendment, and the court recognizes that protection. With prejudice, correct. So no one can bring this suit again because it's not a matter of going out and fixing it. It's a matter of having absolutely no basis to go forward, because in order for defamation to be put onto the table, we mean that the statements have to be false statements of fact. Here we have opinion statements. Those are not going to be defamatory statements then. They do not qualify then. So yeah, it's pretty strong to dismiss any lawsuit with prejudice. That is a pretty high standard, and it is the final ruling. So that's how it goes. We've got a complaint that was set out. It set out statements that were made that he felt were defamatory, but those statements were not false statements of fact. Those were statements of opinion according to the court. That's how they held, and based off of their order that they sent down just on this past Friday, that's how this case has been dismissed. Has anyone ever won a case where the defendant was made? I don't know. I don't have any idea. What's happening briefly? Yes, let me just kind of go through just for these last few minutes and summarize what I've been talking about here today. We have a complaint, Trump versus CNN, regarding some statements that were made, and the response and motion to dismiss by CNN, saying all those statements were opinion and allowable under the First Amendment as opinion political rhetoric. And the court came in and said that's correct. Those statements were opinion statements made as political rhetoric under the First Amendment. Your case has been dismissed. Now, he was asking for punitive damages of $475 million, which is huge. That is a huge amount, no matter what case and what reason. $500 million is a pretty large request for punitive damages. But again, the case was dismissed on Friday. CNN opinion is not fact. Correct. That's right. It's not. It absolutely is not fact. So they can say whatever they want and no consequences. That's not true, Sunshine. The key here is they can't claim that they're stating facts. If they've got opinion statements, those are protected by the First Amendment. But if you come out and you say, I'm about to say something that is the truth, that is fact, and it is not, then now we've got defamation. So you need to spit those facts straight up, or make sure that you understand it's an opinion and that opinions are not facts. They're just a person's view on something, which is absolutely fine, but not to be mistaken as facts, because when we get into false facts, we get into defamation, which is one of those checks on that First Amendment. Yes, and you look to the totality of the situation as to whether or not it's a fact or an opinion, and it may not necessarily specifically say it, although they claim that they did. But if the inference is it's kind of a talk show format, if people are just kind of giving their thoughts on something that's going on, you're looking at an opinion situation as opposed to stated facts. Oh, thank you. Thank you for that. I appreciate the support. Yes, let me move my hands out of the way. Sorry. Sometimes I forget. I don't even realize what my hands are doing sometimes. So, no, they did not state it as fact, James. That's exactly what this case is about. They're not saying that the statements they were making were facts. What they specifically stated each and every single time was that it was an opinion piece, an op-ed piece, put into an opinion format. And because of that, it was all opinions. And even the content of what they were saying had to be opinion. It could not be even perceived as fact. And if you look to see what those exact statements are, that makes sense. When we're comparing someone to a historical figure, those are just opinions. We can't, of course, go back in time and make sure that that assessment is fact, or even project into the future about future content. So again, this is all about opinion statements. And if we've got statements being set out as truth, as fact, you have to watch out for defamation. But in this case, we didn't. We had opinion statements. Oh, what shade am I using? Oh, I'm not sure what it is, actually. I'm sorry. Just something light and easy. I don't really pay attention. I probably should, but anyway, hopefully this was educational for everyone, and you've got a good idea of kind of what's going on here. Again, just going through the black and white of the orders, the complaints, and the response motion for dismiss. To dismiss any case where we're looking at $475 million, I think is worthy of noting what's actually going on. Thank you. Oh, you're welcome. You're very welcome. Thanks for joining me today. Oh, thank you. Thank you very much. I appreciate that. You're absolutely welcome. You are very welcome. I will be going forward and doing other lives in the future. I have already started a couple of different cases, and I will try to continue to go live again as often as I can and kind of explain the different case law to everyone. So that's just my goal here, is to just give you facts and just let you decide what you think should have been what happened or not. My YT username is the same as my TikTok name, so it certainly isn't any kind of a professional page whatsoever. I literally just upload my TikTok lives to it so people can kind of come and refer to it at a later point, or if you need help falling asleep, you can listen to that. So that's up to you. Nice and simple. Thank you, Gary. Yes, exactly. I think so. Oh, well, thank you for the appreciation. I'm grateful for your time and interest and able to talk with people about this. I think it's just so important to actually get the facts, the black letter, what is being written. Just, what you do with it, that's up to you. But it's, I think, good to try to help people kind of find a direction of why things have happened the way that they're happening. So, yes, I do. And we all have different ways of looking at things. Are you doing more defamation cases? I might. I've got some. Usually I take a lot of requests. This was a special request. Somebody had tagged me. And so usually if someone tags me in a news report or something, I will go take a look at it and then try to put together an answer. And so that's a lot of the way that I get suggestions. I also kind of have a list or a docket of things that I'm looking at. But if you have anything that's interesting that you'd like me to take a look at, you can just go ahead and at me on it, and I'm happy to take a look and see what's going on. Just to make sure that it's true as well. Some people have kind of pulled me in, added me in on some things that are completely false, which is interesting. So I'm always happy to take a look and let you know if it's something that you would like more information on. I'm happy to do a live on it. So feel free to tag me if you see something fascinating out there. I depend on my viewers to kind of give me an added hand. So have I read King v. Whitmer? I have not. Is that one I should look into? I can take a look at that. This is probably, this particular case that I just did probably had the most words in it that I tried to be careful about. So I do take a look. Also, I do put an age restriction on my lives, just so people know. I don't on my channel, but I am careful about that. I think if you're under 18, sometimes what I'm talking about just really isn't for you. It's not necessarily something that you need in your world. So I do kind of watch out for that as well. So, oh, this ring, this one here, yes. Oh, yep. I'm a bit like a bird. If it's shiny, I kind of want to go and grab it. So got to run. Thank you. Yes, of course. Thank you for joining. Yes, I do get some very interesting tags. I think the other one was on how to properly make a picnic for your husband. I'm like, I'm not sure that's applicable, but okay. So yes, I will go ahead and probably hop off here as my time has kind of come to an end. I've been on. People are probably pretty tired of listening to me, but You are most welcome. A motion to quash for discovery. I have done a post on motion to quash. So if you go into TikTok and you put in US law, motion to quash, it will pull up my video. So that can hopefully be a bit helpful for you. Yes, of course. Yes. Thank you very much, everybody. Have a wonderful rest of your night. I wish you all the best and take care. It's been great spending time with you on this Sunday afternoon. And hopefully everybody has learned a little bit more than they did before they started. So take care. I will catch everybody at my next live.